you could please take your seats. We've designated the first few rows for students. I don't know who made that choice. Students want to hide in back, but if you are a student, come forward. And given that we're basically out of seats, otherwise anyone should feel free to sit here in front. Okay, great. Hi everyone, my name is Paul Ohm. Welcome to Georgetown Law. I'm a member of the faculty here. I am part of the Institute for Technology, Law, and Policy, which is one of the co-hosts of this wonderful event. In a second, you'll hear from Alan Rozenshtein, who with Chinny Sharma, who's in the back, are the real brains behind this entire event and operation, and the articles that we're celebrating and learning about today. I have been working on this event for a couple of months, but I never really bothered to ask, what are these things your authors are publishing? And so as they've trickled out this week, I've been reading them with a lot of attention. I am so impressed by what Chinny and Alan and these authors have put together. It's a rare feat to write kind of concise, impactful, directed articles about no-nonsense questions about what the law is, but at the same time with a really subtle understanding about the latest changes in AI. I think these are the rare articles where no matter where you are in policy or law or technology, if you're interested at all in that intersection, you're likely to get something useful from these works, and I think they're going to stand the test of time. I also see a lot of my AI law students. I'm teaching that this semester. One thing about these blog posts is I think your final exam just got a little bit harder, I'm sorry to say, because these are such good learning treatises that I'm going to have to make my questions a tiny bit harder. Sorry about that. And then I keep describing the AI moment as the worst family reunion ever, because I now have to go to conferences with IP people, and we tend not. But to me, this is the opposite. This is like Ocean's 11, where we're bringing together, the bomb expert, and I love that about this. I also love that Alan and Chinny have pulled together senior people and junior people and people with really diverse methodological outlooks. It's just such a wonderful day, and I'm super excited to be part of it. As your host, I also have the duty of telling you the restrooms are right outside. The program is super efficient today. We're going to have a panel. We're going to serve you lunch, but you're going to come right back to your seats because we're going to have a fireside chat with someone from the Justice Department, and then we're going to have an afternoon panel. I did want to, as is typical, but when other people do thank yous, they don't really mean it. I really mean these thank yous. First and foremost, I think everyone who's been in the inner core knows that the Institute for Tech Law and Policy and this event would not happen without our own superhero, Samantha Simonson, who's in the back. So please join me in thanking Samantha. Natalie Roisman, our executive director, was also instrumental. Kyle Bernardo's looks like a DJ manning the AV stack over there. These are all wonderful people, and they make events like this really easy for the rest of us to put on, so we're really grateful for that. I'm going to let Alan do other thank yous, but the one he probably is too humble to do is please also join me in thanking and congratulating Alan and Chinny on this day. Congratulations. All right, you'll hear from me again on the second panel, but over to Alan.
Thank you, Paul, and thank you so much for comparing me to the Ocean's 11 crew. I'm just going to assume that you meant George Clooney, and I'm going to cross that off my bucket list. So thanks, everyone, for coming. I'm Alan Rozenshtein. I'm a law professor at the University of Minnesota, and more relevant for today's event, I'm a senior editor at Lawfare, where the articles that Paul mentioned are now up. All 5 are up this week, and you can access them on your program. There's a little QR code. You can also just go to lawfaremedia.org and see those articles and everything else we publish. I want to primarily thank Paul and Samantha and everyone at Georgetown for doing this amazing event. I mean, it's great to have these articles, but it's also especially great to have these articles and discuss them in DC, where so many of the sort of most important folks from companies and policy and the sort of intellectual community are gathered. I also want to thank the Omidyar Network for supporting this event. I want to thank my co-organizer and the real brains behind the brains of the operation, Chinny, for really conceptualizing this from the beginning. Thank all the speakers, the authors, of course, and all of you for coming. Just a word about Lawfare. The thing that we try to do at Lawfare is combine, on the one hand, the rigor, or sort of the highest rigor possible on these really difficult legal and policy issues, but with the speed and accessibility of journalism. And I am so delighted in how these papers came out. I really think they're a model for how to, on the one hand, sort of provide the basic information that folks need to understand these issues, but do it in a sophisticated and kind of opinionated way. We're calling these opinionated primers, right? All the authors are sort of presenting a really good overview of their respective topic, but not being afraid to offer their own thoughts, which will make this a very interesting discussion today. Just two quick housekeeping points. At the end of each of our 3 sessions, we're going to leave plenty of time for Q&A because we have a full and distinguished room here. So as the talks proceed, think of your questions, and then after that, we'll ask you all to come up to this mic in the middle of the room. Also, just so people know, this event is being recorded. The plan is to turn these into sort of Lawfare podcasts. We do a lot of podcasts, so you can also listen to this afterwards and just be aware that this is being recorded. So with that, I'm gonna stop talking and invite our first panel to come up and talk about the papers.
I will not do as many thank yous as Paul and Alan, but I really want to thank Paul and Alan and Georgetown and for all of you guys for being here, and the panelists who authored some of the primers and will be sharing their thoughts on it with us today. So the panel kicking off this event is Old Laws, New Tech, How Traditional Legal Doctrines Tackle AI. I think that when you come up with the cheeky title for a conference like AI on Trial, it feels like a little frivolous, just kind of clickbaity, but now we are in a world where AI means something that we used to think was relegated to sci-fi, and we are also trying to explore liability. I think we've all heard a lot of people talk about it in the news and policy circles, and there are ongoing litigations having to do with AI right now. And so before we jump into conversations about new laws, new regulatory bodies, I think it's important that we review what sort of laws or legal doctrines can apply to AI today. We are generally fairly proud of the common law for being flexible and being developed over time, and there are doctrines that might be very useful to holding AI accountable for harms, and they also have their limitations, and I think it'd be helpful for all of us to know that. So first I'm going to introduce our panelists, and then we can dive in. Both disciplines, and so I'm jealous of that. And his scholarship focuses on software safety, the challenges to constructing a workable software liability regime, and data privacy. And then Kathy is the Segal Family Professor of Regulatory Law and Policy at NYU Law School, and she is one of the nation's leading authorities on the economic loss rule, punitive damages, and federal preemption. So before we jump into liability, I would love to hear from each of you guys. What are the harms? I think I do hear some people say, like, this is all just kind of a silly conversation. Oh, can everyone hear me in the back? Awesome. What are the harms? Is this actually a conversation that we need to be having? Is AI actually causing any harms on the ground? Is this kind of just premature and lawyers trying to have opportunities to talk more?
Who should start?
Yeah, anyone who wants to jump on it.
Well, I would say, so my focus has started with cyber-physical systems, right? Like autonomous vehicles. That's where, like, before ChatGPT happened, we were all talking about self-driving cars. There's cars, there's drones, there's airplanes, right? There's all kinds of software and AI being deployed in these cyber-physical systems. And so that's, I think, the easiest case for some kind of tort liability before you even start to get into sort of non-physical harms. If you can figure that part out, right, then you can maybe extend it to other types of harm and say, do we also care about a broader set of harms? But I think at least that core set should be non-controversial, right? That there can be physical injuries caused by AIs deployed in those kinds of systems.
Yeah, so can people hear me? So, I mean, in the creative space, the harms specifically are harms to existing creators. So a lot of you are probably familiar with the lawsuits that have been filed against the developers of generative AI models that produce, images, text, video that closely resemble, imitate, sometimes substitute for existing work. So, the New York Times is suing OpenAI because ChatGPT is capable of generating verbatim chunks of New York Times articles, and that's a problem if you're the New York Times. So the concrete harm in that space that people are worried about is the displacing effect of these models on existing markets for existing creators. And I won't go into that in too much depth now, but that's sort of the biggest harm that folks are talking about.
Yeah, so it's hard to add on to, but I think it's a great first question. So I'll put it this way. I mean, I think that to start where Bryan started, lots of times actually, depending on which body of law you start with, you jump immediately to a certain type of harm. So if you're a torts, products liability professor, I think you start to think first and foremost about physical injuries and property damage. And one more concrete example is, many people don't realize this, but the FDA, for example, has approved about 700 AI-enabled medical devices. So if you're interested in regulation of, medical products, you kind of have to start thinking about what happens with the component or part of the product that gets put in. If you are in the creative space, you're going to be thinking about protecting, through intellectual property law and et cetera, the kind of creative process. I think the only thing that I'll add to that is that in each of these domains, so I'll speak about torts and products, the introduction of AI challenges you to think about. So for example, in tort law, we have historically put physical injury and property damage on one side and economic losses on another. But yet we think about things like privacy interest as being protected or reputational interest through defamation. So there are definitely things that have historic protection even though they're not physical injuries or property damage. So the AI harm question is a really interesting one and intriguing one because it makes you think about why is it that certain types of harms have been prioritized, what's the functional reason why, and how might AI change that?
Thank you, guys. So you actually perfectly teed up my next question, which was, on one hand, tort law has been relatively flexible in that it has identified or given more life to new harms that might not have existed way back in the day, the origins of tort law. However, on the other hand, it's quite slow to do that, and it can take a long time for new harms to be recognized. So with that lens, Bryan and Kathy, you write about products liability, which focuses on defects in products, and Bryan, you write about negligence, which focuses on the unreasonableness of a developer or user's behavior. Do you mind talking a little bit about each approach and how it differs from the other, and then maybe other examples like strict liability? And then, kind of because these are opinionated primers, why do you think that your approach is better at handling the AI problem than alternatives?
You go.
Well, actually, I mean, so Kathy and I have talked about this a number of times, and I think we share more in common than we disagree, in the sense that we both want some kind of accountability, right? We both want there to be some kind of standard that you're holding, either whether AI is a service or a product, and if it causes harm, that you want to have some way for courts to intervene. So in that sense, I mean, I share, you asked what's better. I think there's negligence. So even if you were to talk about traditional product litigation, right, you have negligent design lawsuits, you have strict product liability lawsuits, right? You can bring those as overlapping claims. And so the real question is just like, how do they differ? And there's some, I think, procedural differences. There's some historical differences in the way the doctrine has evolved, like supply chain or component manufacturer liability or manufacturing defects. But the core of it ultimately comes down to some kind of cost-benefit balancing of, well, was it reasonable, right? And so both strict products liability and negligence use that word reasonableness. And I think, again, what Kathy alluded to earlier just now, should it be just reasonableness with respect to physical injuries and property damage, or should it be reasonableness with respect to a broader set of of harms. And I think the AI question, absolutely, right? It does kind of, and more generally, data analytics or privacy or, it raises those questions of maybe we should be thinking about, again, expanding that set of interests. And you start to see the courts recognizing and pushing in that direction.
Yeah, so I purposefully had Bryan start to see if we were going to agree or disagree. No, but I would agree that at the core, each of us is arguing for the power that common law, whether it's done through negligence-based liability or under a products liability framework, would work to induce, whether it's manufacturers, developers, distributors, people on down the chain, to take safety precautions. And so, and he alluded to this, in products liability, this is kind of controversial ground in some sense, but strict products liability, when it first came into being in the mid-1960s, was focused primarily, the set of cases that it was developed for were basically manufacturing defect cases, construction defect cases, the classic, you all probably read the Escola case, right? The Coca-Cola bottle that explodes in your face. So construction defects are things that are not made according to their blueprint. But there's been a dramatic expansion since the mid-20th century to today of design defect and failure to warn claims. And almost the majority test for a design defect or failure to warn is some form of a risk utility test. So I call it a negligence inflected test. It's looking at the costs and benefits, not of an individual's behavior, but of features of the product. So there's some subtle differences about you focus on the features of the product versus decisions by individuals. But if you take that as a given, then the light between Bryan and my position on the standard of liability becomes very small, because I'm proposing a negligence inflected test. He's a huge fan of negligence and reasonableness. I'll say 3 quick things. They're in what I wrote for today, and I'll try to be very succinct. I prefer, so we can agree, and now I'll try to assert myself, at least to be provocative. I'll overstate. I adamantly prefer products liability framing versus negligence framing for 3 reasons. 1, if you look at the historical evolution, products liability didn't exist in the 19th century, right? It was all in contract. You had to have a one-on-one privity relationship. The history and evolution of products liability from when it first came in as negligence-based liability against a remote manufacturer of a car in the famous Buick versus McPherson test, to how it morphed to a strict liability standard with the exploding Coca-Cola bottle, and the argument that mass production of goods means that we have to have this strict liability consumer expectations test, to the dramatic expansion where the courts moved to negligence inflected tests. We have kind of a historical track record for liability framing to morph and change based on the scale of risk that's being proposed to society. If you go and you read these cases, right, why do we usher in products liability? Because the automobile is a thing of danger that's, subjecting individuals to risk of life and limb. Why do we usher in strict products liability? Because mass production and consumption of goods is very different from one-on-one handicraft. So I have argued that we now are in a transformational technological age, the digital information economy, and similarly, society is facing these heightened scale of risk. So products liability, to me, is a better framework because of that. And then 2 other quick things. The second one is, with products liability, we have a ready framework too when we think about products like medical products I alluded to before that pose really serious potential danger. We have this interplay between regulation and liability. You can have it with negligence. We just have kind of like a track record of how products that expose society to these types of risks can interface in this kind of nice web back and forth, kind of feedback loop between the 2. And then the final is that, and it's related, is we have a lot of examples where we can subject something to products liability in kind of transition, before we know exactly how we would regulate in that area, before we have the precise information to know what optimal regulation would look like. And to me, that seems to fit very much where we are with AI. There's enormous benefits, there's potentially enormous risks, there's not a well-developed kind of here's how we would optimally regulate, and so we could have this running as our kind of transitional mechanism to produce information about what the best way to regulate would be. So for those reasons, I want to be team products liability.
Can I be provocative since Kathy's been
I'm
provocative?
glad.
So-
I asked a provocative question, and you started on such a nice foot. I want to see the distance here.
Well, so-
Advocate for the negligence.
So I would say a couple of things in response. One, so there's I think Lahav has a neat, interesting piece out about a revisionist history of products liability. And so we have focused on the automobile and mass manufacturing in the 20th century as the story of strict products liability. And she says, actually, we got to go back further, right? Food manufacturing, tainted food goods, was actually the progenitor, right? And we know this from Prosser's notes. But there were cases bringing, recognizing negligence claims against food manufacturers and distributors long before Buick and before Escola, right? And Prosser took those food cases and turned it into what we now call, or what he called strict products liability. But negligence was capable of doing all of those things, 50 years before that. The story of strict products liability is a story about a particular moment in time in the 1950s and 60s when we thought strict liability, since you asked about strict liability, thought that strict liability was the future, right? Enterprise liability was going to be the future. And all the way through the 70s, people thought that was going to happen. It was only going to continue to expand to be some form of enterprise or strict liability. And that hasn't happened, right? So when products liability first came out, it was, well, maybe we shouldn't care about foreseeability of the harm, right? Any harm, no matter what, if it's caused by a product, right, it should be compensated by the distributor or manufacturer of that product. And whether you could foresee the injury or not, that doesn't matter, because all we care about is compensating the victim. That turned out to not work very well, right? And so courts kind of pulled back and said, no, actually, we do care about foreseeability of harm. And so in those ways, actually, the gap between products liability and negligence has narrowed. And so the question is, what is the remaining value of products liability, this experiment from the mid-20th century with strict liability or enterprise liability? How much of that actually continues to be useful in the AI space? And one way in which I say it might be a distraction is because AI folks love to say, it's the technology. AI is autonomous. It's working on its own. There's no human in the box, right? There's no golem inside. Don't worry about it. Even though we know in actual practical implementation, there's always a human team behind the scene. There's always a person in the loop, right? There's someone monitoring. That's the only way they can get AI to really work, on the edge cases. And so I think it can be a distraction to say, focus only on the technical features.
I love it. We got to some disagreement. So kind of moving to Katrina, perhaps surprisingly to me, as someone ignorant of intellectual property law, but maybe unsurprisingly to people who focus on intellectual property law, I feel like IP law came out swinging as generative AI hit the scene, with being some of the first types of doctrine that was being applied in actual lawsuits against generative AI developers. Do you mind talking a little bit about the origin of these cases, what's currently going on in litigation, and what kind of harms they're addressing?
Sure. So there's a lot to unpack here. So the harms that are occurring in the creative space are very visible. So if you're a visual artist and a generative AI model has been trained on your work and it's able to produce work that looks a lot like your work, then it's really scary, right? You're really worried about losing your job. And so a lot of artists and authors and journalists and other creatives filed copyright lawsuits really early. But what I will say is that copyright is not a general purpose policy tool. A lot of people try to use it for non-copyright purposes because for a few reasons. So everything is copyrighted, right? All of the photos that you've taken on your phone, all of the emails that you've ever sent, they're all protected by copyright automatically. Obviously, if you want to sue for infringement, you have to register, but that's a separate thing. Everything is copyrighted. So basically, everything is suable. The other reason is that copyright has really powerful remedies, right? So you can get injunctive relief, you can force people to take things down. Statutory damages are very, very high, to the extent that courts ultimately decide that AI training is not fair use. Then if you consider the billions of works that are used to train these models and the statutory damages that could attach to each of them, like the damages are potentially crippling to any company. Maybe not OpenAI, but many companies. And so there's a reason that copyright is often the sort of go-to tool for taking content down, because of these things that I've described. When I say it's not a general purpose policy tool, I mean that there are so many scary things about AI, not just the potential displacing effect on existing creatives, but also like really fundamental questions that we have to ask ourselves about, like what kind of creativity do we value? What kind of expression do we value? What kind of society do we want to have? Do we want a world where everything we see online is AI generated? Yes or no? And there are reasonable minds that disagree about it. But copyright is a narrow tool. It protects original expression in creative works, but it cannot resolve these fundamental social questions about the value of human creativity and what kind of creativity we want to protect. And so, asking the courts to make these very narrow decisions about, is unlicensed training fair use? Is a substantially similar output infringing? Like, those are narrow questions, but copyright cannot answer these broader sort of social and cultural questions about what kind of markets in creative expression we want to have. So that's what I mean when I say that, like, although I understand why copyright has been sort of the go-to tool for decelerating the pace of AI innovation, it's not actually a great tool for addressing all of the ethical implications of this technology, and I don't think we should be trying to do that using copyright.
You kind of foreshadowed my next question, but to drive it home a little bit more, to illustrate kind of the point that you're making about copyright not being a general purpose tool, but it being used for things beyond what it was traditionally intended to protect. There have been a lot of conversations about using copyright to address things like deep fakes or the distribution of non-consensual intimate images. Can you talk through, like, what is the theory there? How are they trying to shoehorn these cases into a copyright framework?
Yeah, the reason that copyright is sort of the tool that people instinctively reach for is because, as I said, everything is copyrighted, it has great remedies. With harmful content that we want to take down, there is a long history of copyright owners using copyright in that expression to take it down. If someone takes a really like unflattering image of me and they post it online, and I want to take it down, maybe I think that I can because I'm the subject of the photograph, but if I didn't take the photograph, I don't own the copyright in the photograph. So people have talked about using copyright to remove things like non-consensual intimate imagery. There's a whole body of scholarship on this. Amanda Lewandowski, for example, has done amazing work in this space. I'm not saying that that's not an option with deepfakes, but copyright doesn't seem like the right tool for that. Like, strictly doctrinally speaking, if someone takes copyrighted content like images or photographs or videos and then turns that into a deep fake, like regardless of sort of the social and ethical implications of creating a deep fake, that's probably transformative fair use. So I can think of a lot of artistic and other socially beneficial deepfakes that people probably don't want to use copyright to take down. But if we use copyright to take down deepfakes, then we have to take down all of the deepfakes, including the good ones. So some of you may be familiar with deepfake Tom Cruise. That's generated a lot of followers on TikTok. I mean, the harms associated with that are pretty minimal. Like, I really enjoy them. But if I wanted to use copyright to take them down, then I would have to, like, basically shift doctrine and say, well, taking copyrighted images and videos of Tom Cruise and then turning them into a deepfake is not transformative fair use, and it probably is. So I think the legislation that has been proposed to specifically address like really harmful deepfakes, and I'm thinking of sexually explicit deepfakes, non-consensual deepfakes. I think that legislation that's specifically addressed to taking down those deepfakes is really important, and I support those. And I don't think that copyright should be used for this purpose because I think it would distort the doctrine in a way that the broader ramifications of which I don't think we would actually be on board with.
So I love that because I kind of want to get to, I feel like lawyers or academics often get the bad reputation and maybe the deserved reputation of being very abstract or focused on doctrine or theoretical underpinnings of law, as opposed to the reality of what happens when you, for example, use a traditional area of law to use cases that it was not envisioned for. So I kind of wanted to ask, starting with you, Katrina, and then if Bryan and Kathy, if you have thoughts on this, you used the term distraction, Bryan. Is there any downside to right now focusing on, well, in the short term, I want to use this theory of liability to hold AI accountable? There's like a zero-sum game in terms of attention. Maybe instead, if we couldn't use these doctrines, we would focus on more comprehensive substantive regulation. Maybe we would force courts to move into like a different area, create the new design defect that addresses something like this. So how would you think about the trade-off of, in the short term, we can maybe hold accountable AI now under these traditional doctrines, versus the long run, maybe using this both has distorting effects on the doctrine and kind of gives us a get-out-of-jail-free card on not actually addressing meaningful substantive regulation that would get at all of the policy issues?
Yeah, so it's a good question. I think, so I understand why people want to use copyright to take down content that they're unhappy with, AI-generated content in the short term. I think it's going to take a really long time for courts to decide, right? So if the Google Books litigation is anything to go by, it may take a decade before we get, and I mean like a definitive answer from the courts about whether unlicensed training is fair use. And so in the meantime, people are going to do other things, right? So copyright owners are signing licensing agreements with AI vendors to make sure that regardless of what the courts say, they get a slice of the pie. There are artists who are using technical tools to protect their works from unauthorized scraping, so like data poisoning attacks or watermarking. So in the meantime, people are going to turn to short-term remedies. I think over the long term, I want courts to give us an answer. I don't think platforms ultimately should have sole discretion about what is infringing use and what is not. But I think over the long term, probably copyright will only be able to answer like a very small fraction of the questions we actually want to ask ourselves in terms of how is generative AI going to contribute to sort of the marketplace of ideas and the kind of cultural expression that we value.
So I do want to respond. So I heard two questions in your, so one is there a substitution effect, right? If you focus on litigation, is it going to have some kind of, downside for other forms of regulation? And the second question you said is, what are the unintended effects of, misapplying a liability theory, right? On the first question, I think actually it's not a substitution effect, it's a complementary or boosting effect, right? Oftentimes the court makes a decision and the Congress says, oh my gosh, how could you have made that decision? We have to now pass legislation to undo that court decision. Or it can spur, like it says, the courts are recognizing this cause of action. Let's now make that a piece of legislation because we think that's a good idea. So I think there's Kathy's written a lot about this, right? The feedback loop between, agencies and courts, but also between Congress, right? The institutional bodies. I think that's like super important. And sometimes courts are faster at moving than legislatures, right? So I think it's a false dichotomy to say that one, focusing on courts will somehow prevent us from getting action in other domains. I mean, the revenge porn statute, that's been going for a while now, right? Okay, so the second question is misapplying a liability theory, and here I'm going to come back to strict products liability, which is unintended effects, right? In the 50s, 60s, we thought we could just throw liability on the manufacturers, like strict liability, that's fine, nothing's bad's going to happen, and we had these sympathetic plaintiffs, right, victims who are being hurt by exploding soda bottles. Of course, they should get compensated. Let's just give them money. And then in the 70s, we had a liability insurance crisis. And a recession and other sort of cash flow problems. And so the court said, well, actually, maybe that wasn't such a great idea. Maybe we should pull back on these theories. We don't have infinite buckets of money, right? So, Kathy, again, has written about how insurance infuses the tort system, right? That it's like a critical component of how the tort system operates. And so I think we have to be mindful of, just saying there's a sympathetic victim, therefore we should have a liability theory. No matter how contorted it is, that probably will have downstream consequences.
I think that the power of the common law is very strong, and I think that people sometimes only recognize it in times of regulatory failure or regulatory inaction. It's very interesting to see people, for example, who are interested in regulating all sorts of areas of health and safety, who have not a whit of interest in the common law, when suddenly their regulators aren't doing anything, that they become really intrigued, right, with the common law. Like Bryan, I actually think there's a complementarity, and sometimes the common law is a good place to look for where there's regulatory failure or inaction. But I think the power of it, if you look especially historically, is even greater than that. And Bryan alluded to there are multiple instances where the common law actually did a very good job, as I've argued in sort of transition, surfacing the need for either legislation or regulation, and better legislation or regulation that happens after a period of this transition than would have happened at the outset if we're worried about misfiring. Bryan talked about, I have a slightly different, I don't want to get down into the weeds, view of the evolution of products liability, but I would agree with him in one thing. Negligence is the road not taken. And because it was the road not taken in products, which then morphed to a risk utility negligence inflected test, the reason I would prefer that framework is we just have a body of evidence to look at how we can combine ex-ante regulators like the FDA with products liability. But we'll leave our, in the weeds fighting maybe aside for a minute to make the broader point that I don't believe that it's a distraction. It's sort of like that we have some idea of how we would optimally regulate, and if we would just think harder about it today, we should regulate in the optimal way. We have dramatic uncertainty. Take a different example, fracking, right? There was a time some years ago where we had no idea what the costs and benefits would be. I know there's now political arguments going on. I don't want to be too controversial, but the idea is if we didn't have tort liability to be down there and surfacing, the actual realized harms that were happening and people coming forward in litigation, thus giving us some information about the scale of risks and benefits, we would have no idea how to sensibly regulate. One final example, think about online platforms, right? Amazon historically was saying they were not a seller of products because they never transferred legal title. In fact, their whole business model was designed, even when they take products and put it in their Amazon warehouses, they never accept legal title. So no one was regulating them. And actually in the courts for a long time, they were winning on these arguments. We can't apply products liability because they're not a seller. And then the dam broke. And actually courts are now there's still division, but the California courts led the way of saying for functional reasons, it's not just transfer of legal title. That was like a historic proxy, and we have to get over that and think about what it is why we hold someone liable as a seller and started imposing liability. And then lo and behold, there's all sorts of legislative proposed bills or regulators, right? That's just the way I can think of a lot of examples that go that way, and I can't really think of a single example where the common law working in this transitional space crowded out the energy that we would get, and they do work hand in hand. I mean, we would probably get there faster if we had a lot more, governmental money going into independent research on risks and benefits. I'm not saying that the tort system is perfect or the only way to go, but we have a lot of historical examples that at least give me confidence. The comment that I'll make, it's interesting hearing Katrina about copyright. So sometimes, for example, people would say, similar things about products is not good because a seller is someone who transfers legal title, or product isn't good because a product is a physical, static thing. I actually like to get quite theoretical and conceptual and look at why, right? It's not the thingness, the static physical thing that meant we should apply this framework, nor, right, as courts now are telling us, is it the fact of transfer of legal title that meant you're a seller. You have to look to the underlying reasons, and in that way, at least in the tort law space, the courts can be quite flexible and adapt and morph, and they can actually, as I said before, surface kind of information about risks and benefits in a way that otherwise we're going to be at a loss to how to do this optimal regulation.
That was great. And because you called out the Amazon case, I think I see Carrie Goldberg in the back, so just shout outs to Carrie for doing God's work bringing these products liability cases to the courts. But I think the three takeaways I got from that was when we think about using doctrine for instances that it was not originally intended for, we have to think about, do we want it to apply to all of the potential cases that it could be applied for? Take down bad deepfakes, maybe take down all deepfakes. I think there is a point about the reinforcing nature of regulation and the common law and the information forcing mechanism that the common law can have, whether it is products liability or negligence. It can actually be more flexible and unearth places where regulation should step in and reinforce what the common law is already doing. And then the last thing, which I think is often forgotten in these conversations, is the common law has a massive body of law. So it kind of matters whether you decide to go with negligence or products liability to some degree, because you're importing this whole history of doctrine and the kinds of cases that are applied and the way they've resolved issues. And so kind of looking at which one do you feel more compelled by, or which one do you think those analogies are more effective, really matters. So to kind of specifically a aspect of negligence, Bryan, you write about professionalism and holding AI developers accountable to a customary standard of care in negligence lawsuits. And so basically treating AI developers like we would treat doctors or lawyers in the court context. So do you mind talking a little bit more about that? And then do you think that that might be a useful way to get at some of these more amorphous harms that traditional negligence or like a focus on products or outcomes might have a harder time getting at because of the focus on physical harm or economic harm?
Yeah, I appreciate the question. And so Chinny's written about this as well, AI's Hippocratic Oath, and so you should go check out her work on professional licensing of AI engineers. So Kathy alluded earlier, there's massive uncertainties in this area, and I agree. And because of those massive uncertainties, I think it's not just about what kinds of injuries could happen or what the risk benefit is. I think it extends to what are the best practices, or even the standard practices that AI developers should be following. And if in fact there is that kind of uncertainty and it's not resolvable by some kind of collective scientific community, then I think that's what calls for an alternate standard like the customary care standard. So the sort of canonical place where this standard is applied is medicine, right? The practice of medicine, there's just a lot of uncertainties. There are things that we kind of know, but also there's just a whole lot of things that we have no idea why this works. We don't know the pathways. Each patient is a little bit different. So we'll try a recommended course of treatment for 2 weeks, and then if it works, great, but if it doesn't, we'll try the next thing, right? And you have communities of physicians or healthcare providers that have just disagreeing philosophies about how the best way to treat. So this goes back to, again, the 19th century, right? There's alternate medicine, there's homeopathy, there's traditional medicine like bloodletting. There's a whole division of sects of medicine that disagree fundamentally. And so here too, you can draw that analogy to AI, right? That there are, maybe differences in opinion about what the best way to, provide guardrails, or the best way to train, or the best, are transformers going to be the way, for all models or just some models? How much do you iterate? There are these kinds of question marks that I think until they're resolved, we might be better off saying, let's wait and see and figure out where the consensus or the areas of consensus are, where the areas of consensus are not, and that, at least my sort of interest in adopting that standard is not to take a hands-off approach, but to allow courts to use that as an entry point to say we are not going to sit back and say, we can't adjudicate these cases. No, we can, because we're going to apply this customary care standard, and that's a way to get law involved.
Kathy, do you have a response? Because I know that we've had conversations in the past about using the customary care standard versus products liability to get at these same issues.
Yeah, I'm going to now be more conciliatory, and then I'll try to sparse. So I think, because Bryan made a point earlier, and I just want to echo it, that a point of agreement actually is the power of attaching a form of tort liability. And one of the reasons that I think we both share is actually this interplay between tort and insurance. So there's also a whole idea about how when courts, when they're facing new risks, so taken like the data breach context, for a long time because they were conceiving of the harm as maybe purely economic losses, there was a thought that there'd be no duty of care to impose, whether it's under negligence or under some form of products liability. And once there's a threat of that, so once some courts started saying there is a duty of care, then there was a lot more interest in not just first-party insurance, right? First-party insurance is stuff like the people who are worried about a data breach are going to be worried about their own business's losses and getting like a forensic team and maybe even lawyers involved with data breach notification. Third-party liability insurance you only need if there's a threat of liability, right? And so the component of third-party liability insurance works in a way that I think many people don't appreciate enough. So it works not just to spread losses, but it works as a form of risk management. It varies across different areas of the law, how well it serves that function. But one thing insurance can do is aggregate information, right? They can actually come up with the kind of protocols and standards along the lines of what Bryan's suggesting might be a kind of, it could feed the idea of what's customary. They could come up with protocols that they're going to insist upon then in sort of the data breach area that people use, certain safety mechanism. So if the idea is how are we going to search for information about how to prevent or mitigate harms, we should really be thinking about the power of insurance, liability insurance in that realm. So now though, maybe to sound a disagreement, again, I don't want to do so too forcefully here. There's an interesting analogy that I have in mind. So when a doctor is using a medical device, even an AI-enabled medical device, versus a movie theater that like serves popcorn, right? The courts have wrestled with this question, have said, well, you don't sue the doctor for products liability. You sue the doctor for malpractice and how they might have used this, and then you sue the product manufacturer. So first point is like, they're not mutually exclusive, and there are reasons why you would want to have both forms of action, one against the doctor for malpractice, one against the manufacturer. Whereas at the movie theater, the courts have been much more willing to think about the idea that you can hold the theater liable because they're doing movie, they're filming the movie to you, and that's separate and apart from they're selling you something over there. So they're intriguing questions. In some sense, whether you start down Bryan's road or my road, I feel like you're going to get to some conceptual difficulties that are going to face us no matter where we start. So one is this products versus services kind of divide. Another will be professionals. Bryan has, knows about this and alluded to it in his writing, but hasn't mentioned it here. But even in the restatement on liability for economic harms that basically says as between contracting parties, you can't sue in tort for purely financial losses arising from the performance or negotiation of the contract. There's an exception for professionals. And of course, doctors and accountants are professionals. Everyone else, the courts are struggling, are engineers, are architects. Who's a professional? Because it matters, because they can be sued not only in contract, but tort. So there's a big, you have to answer the core conceptual theoretical question, why? Why does it matter? And what's at stake in terms of this? And the final note I'll just say is just, it is interesting to listen to judges try to figure out who is and isn't a professional. So, they come up with criteria like, do you have to get a license? Do you have to go to a lot of training? And then suddenly when the example of a masseuse gets put forward, they have to get licensed, there's lots of training. Oh no, we don't mean that. So what do you mean? There's like an intriguing question of why professionals have this kind of carve out and what professionalization means. And we have well-developed bodies of law that lawyers have always fit that bill. And for, AI developers, et cetera, you'd have to answer the question of, why would you want to treat them different from all other providers of services that might lead to harms?
Can I add just one quick supportive comment, which is on the liability point. In medicine, we often worry that too much liability will cause doctors to practice defensive medicine, and that might be worse for patient care. But think about, would we want AI developers to practice defensive AI practices, right? Maybe that's not such a, maybe it has a different valence. And so I just wanted to kind of add that point.
I love it. And just, I think some in the crowd are also cybersecurity folk, but I think the point about the role that standard of care, tort liability, contracts, and insurance all play is very complicated. And in the cybersecurity context, we've actually seen that insurance companies have stopped insuring certain companies, and we've seen that tort liability or regulatory action hasn't been enough to change company practices to make them more secure. So it is just like a real finesse of how exactly you apply these things. So that kind of gets me to my next question, which is, one of the hardest things is the supply chain question in a lot of areas of law, negligence and products liability and copyright. And all of your primers talk about, well, liability would attach differently depending on who you are in the AI supply chain. So you have like your AI developers, and like even there, you could be your foundation model developer, you can be a fine tuner, you have AI deployers, so you have companies that are like, I'm using AI in the provision of my products or services, and you have AI end users, or the services or products that I am receiving is the AI. Do you guys mind talking about kind of how negligence, IP, and products liability would treat those parties differently, and where it might hit stumbling blocks there?
Sure. So I can't answer this question without pointing everyone to James Grillman's, I think, Paul, you described it as his magnum opus. He, Catherine Lee, and Fede Cooper have a phenomenal article where they detail very comprehensively all of the liability issues associated with intellectual property within the generative AI supply chain. Don't be put off by the length of the paper. It is worth it. It is like 100% worth it to read it from cover to cover. I think I've done that twice now, so highly recommend that. So that's the first disclaimer. What I will say, because it's hard to summarize sort of the liability attaching to each component in the supply chain in a brief answer, is that it is important, and it will be important, and we'll see this unfold in the courts, to like break down the generative AI supply chain into different chunks. So you have the person who creates the, I don't want to say person, entity, the entity that creates the training data set, the entity that trains the model, the entity that fine-tunes the model, the entity that like aligns the model, the entity that deploys the model, and then at some point you have the end user, and how liability will flow from the actions of each party towards both like the issue of our AI inputs infringing, and then the separate issue of our AI outputs infringing is like a very difficult and complicated question, and it will take a long time to see how that shakes out in the courts. What I will say from like a risk-averse perspective is like you should probably get a license for training data. Also, if you're creating a training data set, you should think about like who's going to use that data, right? So if you feed that data to a model that you know is going to be used for infringing purposes, maybe don't do that. So sort of, you know, in line with these discussions that we've been having about like reasonableness and standard of care, if you are contributing to a supply chain that will ultimately end up with a generative AI model like Midjourney or ChatGPT, you should probably be thinking about how your contributions will have downstream effects on what users are capable of producing and whether models will generate memorized outputs. And by memorized, I just mean verbatim or near verbatim copies of training data. So all of this stuff matters. So, you know, just because you're further upstream in the supply chain, you know, you've created a training data set and then you released it online, you say, I wash my hands of it. The courts will probably say that you cannot, and you have to think about like how your decisions, even as upstream as you are, will affect parties downstream. And I say this because copyright owners and the ones that are suing tend to be deep-pocketed, and they will continue fighting you in the courts until they get the answer that they want. So all of this is to say, be careful, probably get a license for your training data. The biggest issue, well, one of the big issues that's sort of playing out within IP scholarship at the moment is whether or not training is fair use. There's a theory of non-expressive fair use that was developed by Matt Sag that people are disagreeing about whether or not it applies to generative AI. So if you think about something like a search engine, right? Like a search engine, in order to index web pages, has to make copies of them. Those copies are not authorized. Does that mean that the search engine like Google has engaged in infringement? No, because when it makes those copies of the web pages, it does so in order to generate metadata about them, to index them, to process effective search results. It doesn't make those copies in order to communicate the expressive content of those web pages to a new audience. So similarly, in the context of generative AI, if a model is learning from its training data how to produce content that looks similar, people have argued that, well, these copies that the model makes in order to learn, those copies never see the light of day. They're contained within the belly of the machine. That's clearly not expressive fair use. But the thing is that, we know, because there are plenty of examples of this, that models are capable of generating verbatim copies of training data, which means that the copies the model makes within the training process are being shown to a new audience. Like, you see them in the outputs oftentimes. So whether or not this theory applies is, again, a matter of deep contestation. We won't know for a long time whether or not it's fair use. But in the meantime, if you want to avoid liability, be careful.
Wise words.
So I want to give, I want to, not surprisingly, argue that, products liability is kind of a mature doctrine that has faced all sorts of difficult issues. So it is not the case. Sometimes I talk to people and I understand it. One of the great things about conferences like this and other things is it's bringing people, non-torts, non-products liability people, into my world, not administrative law, and it's bringing me into a broader world with other scholars. But I think sometimes people have this idea that products liability means you're a manufacturer, et cetera, you test, you design, you put something into the stream of commerce, and then you're good. And in fact, all of the wealth of cases about failure to warn under products liability are all about how you have post-sale duties to warn and under what situations, how there are continuing duties that you have to, when new risk evidence comes to life, that you have to do, comes to light, you have to do something about that, et cetera. There's all sorts of, I'll talk about, there's a case before the US Supreme Court, which is kind of exciting. Tort cases don't often get to the US Supreme Court, but this one was under Admiralty. But the basic idea was someone made a bare metal turbine, right? That's what they manufactured. And then down the road, someone put in asbestos-laden gaskets. And the US Supreme Court had to decide, does the original manufacturer of the bare metal have some duty to warn on the basis of the dangerous thing that got inserted down the road by someone else? And to my elation, both the majority and the dissent in that case applied like a cheapest cost avoider framework. You might have heard about Guido Calabresi's view that in tort law we try to impose liability on the party that could most readily have averted or mitigated the harm. So the majority and the dissent both do that. They come to differing conclusions. So on the one hand you think, oh great, just what academics love, come up with some theoretical framework that in practice could come out either way. But to me that's the power of it, right? Because in different types of situations with different things happening all along the chain, you can't always say that the cheapest cost avoider was the person fine-tuning here or the cheapest cost avoider was up there. But in a fact-specific dispute, you can ask a court, and if that's your framework, what the majority in that case decided is there was a duty to warn, that actually that bare metal manufacturer was the entity that had the best information about how this was being used down the road and how they could have taken measures to avert that kind of harm. So to me, that's very powerful, and it suggests that in this world with all of this complication, we kind of have a framework that's already had to deal with that. The one other thing sometimes people say is, oh, we've never had to deal with something that learns out in the world. Of course we have. Again, think about drugs, right? We require a ton of information, 3 phases of clinical trials, the FDA signing off. But what happens once a drug goes out into the world? Well, it interacts with everybody's different body, et cetera, in a dramatically new way where we get new information about harms that were or weren't anticipated. So and we have a framework that says when that new risk evidence comes to light, guess what? You can sue in products liability unless you've gone back to the FDA with that information. So that's a wonderful feedback loop. It's not that it couldn't happen under just a pure negligence world. In fact, again, the light between us is quite small because these are courts applying a negligence-inflected test. I have no problem with negligence as a standard of liability. It's just we have this well-developed model, and I think it's a model, not that everything's going to be easy, and we know ahead of time this entity will always be liable. I mean, you know, we have, regardless of what we might say about the US Supreme Court, right, they were on both sides of this using the same conceptual framework, and they just saw the application of the facts to that a little bit differently. But to me, that sounds like a very good model to test out and see in different kinds of scenarios.
I'll just say I think the supply chain question is is a really interesting thing. It's a very fertile ground for further study, both in the software context and in the AI context. And I think the IP sort of case study or example, right, it really brings to light how the supply chain is really can be really problematic, right? Because I think there you really see the AI entity or the developers, sort of having lots of different, or like sort of not controlling the entire supply chain. So in other contexts, like in cars, you have the entity is trying to control all the things, right? All the sort of case studies, the examples, how many miles you're driving, the corner, pedestrian examples. All these things are generated by the company. They're sort of all in-house, and so you could say, well, it's easy, right? There is no supply chain problem because it's all happening under one entity. But the concern that I would have, and that's kind of foreshadowed by the IP example, is if you start to bring liability and the companies start to get anxious about that, then how do they respond defensively? Do they start to farm that out? Do they outsource it? They say, actually, we're no longer in the business of manufacturing data. We're going to ask another entity to handle that. And so that, you see the same kind of thing happen with car manufacturing, right? It's not, you have different manufacturers that they make tires, that make other kinds of components, and you sort of farm all that out and you outsource it. And I will say, one area where products liability does have an advantage is in this component supply chain problem. And I'm totally comfortable with that. I too do not have a problem with product liability in that sense. So I would be supportive of having parallel actions, especially when there are certain problems that one theory can solve better than another theory can.
I could ask questions all day, but I'm going to open it up to Q&A. So we have a mic in the middle. If folks have questions, please line up. Would love to hear kind of what is actually interesting or confusing to you guys. I think, it would be great to be on the central mic so that the podcast can pick up.
Why do you need the mic?
Yeah.
Hi, good morning, everyone. I'm Lovett. I'm actually an AI governance professional and also the founder of Voice of Responsible AI Group. It's a platform for minorities to talk about AI governance and how it affects us. So I think my question is for Bryan. I know you talked a lot about product liability. I know within the context of the United States, can we classify AI as a product? And if so, looking at the case in New York, Rogers versus Christie's case, the court actually ruled that an AI is not a product or a service. And for those who don't know about the case, it was a case between a lady called Christie, whose son got killed, I think 3 days after someone was released from jail. And an AI algorithm was used to make the recommendation for the guy to be released from jail. So she's claiming as a result of the release, her son got killed, and is suing the state of New York for, I'm not a lawyer though, responsibility for the son's death. And that case was actually, I think, she lost from what I read, and the argument was that AI services are not like products. So in the current context, where do we stand looking at a case like that when it comes to AI?
Yeah, no, I would pass the baton to Kathy because I think your piece really talks about this.
Yeah, so it's a great question. It's a cutting-edge legal question of the extent to which you could consider. So there's cases against social media platforms, and courts, actually in California, courts have gone in different directions. There's a state court case and there's a federal multi-district litigation. And so what I'll say is, and I talk about this a little bit in my piece, is that a court that's going to say that a product is kind of a traditional, tangible thing and static is going to be more likely to say AI and social media platforms cannot be a product. That's happened at the state level in California, in this California case. At the federal level, the court actually decided that, and it analogized, it kind of still used this tangibility criterion, and it analogized the idea that you can make social media platforms with certain types of features like parental controls, et cetera, and it analogized it to, like, in the physical world, you can buy prescription medication and there's like a child safety lock, and in that sense it says we should go forward. In my piece, what I argue is, you know what, that tangibility line served a kind of historic purpose, but I think we have to get over that, and I suggest two things. One, doctrinally, courts have started to look at the idea of the mass production feature and the mass production of something leading to high scale of societal risk, and saying that's why we decided to use products liability historically, so maybe that's why we should do it, you know, today. And then I end, not surprisingly, with a kind of rally call to cheapest cost avoider, and I point to a case, it's a Florida case against Lyft, where the court held that the application could be treated as a product. It was a horrible case in which a Lyft driver was distracted because they were required to respond to certain questions and they hit someone. And the argument was, why? Well, there's some arguments that this isn't a service. Interestingly, if you look doctrinally, and I think Bryan would agree with me, the courts are all over the map about what's the difference between, they'll say a service is not a product, and then you say, okay, what's a service? I don't know. Sometimes it involves humans, discretion, but in any event, this court instead said, we're going to hold Lyft responsible because they're the ones who could have avoided this kind of harm by the way that they were designing that app. So to me, that's the right reason to say something's a product, but that's not like traditional doctrinal analysis, and the courts, in my opinion, have to lose their hold on tangibility the same way they had to lose their hold on transfer of legal title to get into that, but it's a great question.
Thank you.
Thank you. Last one.
I think we're going to limit for now to one person, one question. If we have time, please come back up.
Hello, I'm John Bergmeyer with Public Knowledge. So in the discussion of the different liability regimes, I keep thinking of how software per se almost has its own unique liability regime, since software licenses almost always have these ridiculously broad disclaimers of liability, not fit for any purpose and so forth. Stuff that would clearly be ridiculously unenforceable if a power tool tried to say, oh, we're just not liable, and it's allowed due to the magic of, well, it's copyright software, it's a license. Well, anyway, so what sorts of moves would be necessary to prevent this from happening to AI? Regardless of what regime you pick as the best default regime, how do you just prevent AI companies from just finding ways to just get out of it by software licenses or contracts and such? I'll take my answer off the air.
Yeah, well, I'll start, but I'm going to hand it right back to you, because the answer there is that tort has not been applied in many software cases because of something called the economic loss doctrine, which is something that Kathy is an expert on. And the contract disclaimer applies to warranty law and to contract law, right? If you want to disclaim any warranties or fit for purpose, right? Then you need that language in your you have to disclose that to the purchaser of the product, right? And then you can disclaim it. Warranty in sales law allows you to do that. That's why those contracts are there. Now, if tort law applied to software, they wouldn't have any effect, right? That only applies to this other area of law. And the only reason it has been so effective is because the courts have said, well, we're not going to apply tort law to software in most cases, unless there's physical harm or property damage. And of course, harm to the computer itself has been ruled out. That's not the kind of property damage that we mean. But I'm going to hand it back over to Kathy, because you've written about this as well.
I mean, I agree with that, and I would only add so first of all, I think sometimes, as you mentioned, that there'd be these disclaimers, and you wonder, what is the disclaimer doing? Because you look at something and you know it couldn't stand up in court. So I don't know if you've ever, I'm idiosyncratic, I realize, but I read disclaimers all the time in things. For example, like a field trip that a child might have to take with school, and they disclaim liability not only for negligence, but for gross negligence, for recklessness, for kidnapping. I mean, you read this and you think, you know, who's the legal team that, and you know, I've had discussions, and same thing, you know, you go skiing and you're being, you know, not only do you assume risks of regular negligence, but you cannot sue if someone, you know, intentionally throws, like aims a snowblower at you and guns you down. Like, these are absurd. They wouldn't hold up in court. The road not taken, that, you know, again, I'm going to leave this for Bryan and I to continue to battle out offline, but one of the reasons it was the road not taken through kind of like contract and negligence, it could have taken that road in terms of like very much sharply saying under contract law you wouldn't be able to disclaim these kinds of tort liability things. Instead of going down that route, we switched everything at a point in time over into products liability and handled it there. But I'm not worried about, you know, if you can articulate like a design defect that's leading, yes, it's easier for physical injury and property damage, but it doesn't stop there. It can be privacy kinds of harms, it can be reputational harms, and then even in the economic loss rule, Bryan mentioned, like when you have a product that just destroys itself, that's purely economic loss, but if it injures other, like if it's a product that injures another part of the product, and so there's an interesting question here about if you're going to articulate sort of AI as a product, and then something happens to something that hurts the other product, then you could get liability there, tort liability as well. So it kind of comes back to your first question.
Moderator's privilege to kind of bring Katrina into the conversation. Do you mind? I feel like it's often, like we don't talk about this a lot in software context, but the idea of software as a copyrightable thing with licenses as a core part of its distribution. Do you mind just talking a little bit about kind of if there is a unique aspect to how these licenses work in the software world and why that might have led to this weird world of these disclaimers maybe not being legally enforceable, but in practice on the ground kind of just ending up with people not bringing cases against software manufacturers?
Yeah, so software is definitely a strange one. A lot of people don't think it's, well, some people don't think it's creative and deserves copyright protection. It's obviously highly functional and utilitarian. Software programmers obviously argue that it's deeply creative and deserves protection. There is currently ongoing litigation against Microsoft and GitHub because open source software from GitHub was scraped and used to train their code completion model Copilot. So that's ongoing litigation that's relevant for the generative AI space. Within copyright specifically, there is this long-standing tension between copyright and contract law. I can't speak to disclaimers of software, like in terms of what software is intended to be used for, but there is this interesting tension between software distributors who want to impose restrictions on how software users use their products and what copyright says they can do. So courts have generally recognized practices like reverse engineering software as fair use, but software distributors are really mad about that, so they include terms within their software licenses that says that users cannot engage in reverse engineering. So there's this sort of battle happening between what software manufacturers are trying to prevent users from doing with their products, and then what copyright under the book says that they actually can do. And then, you know, that leads to sort of broader questions about what is the best tool to regulate markets and creative expression. Is it contract or is it copyright? Is the copyright statute an onerous one-size-fits-all standard form contract? Should we allow parties like software distributors to, you know, exploit freedom of contract to contract around statutory limits on their exclusive rights? This is sort of like an ongoing question and one that I cannot resolve today.
It's a theme.
Hi, thank you. My name's Dean Ball. I'm a research fellow on AI policy at the Mercatus Center. So it seems to me that any liability regime, and I've tried very hard myself to sort of figure out how these various regimes would apply in practice, there's like substantial uncertainty as to how it would actually all work. And at the end of the day, we're kind of leaving ourselves exposed to whatever the fact pattern is of the initial cases and sort of what the judges decide and what the general mood is toward AI at the time that those cases are decided. And I just wonder if you all balance the kind of, there's the intellectual satisfaction of getting this right. And then there is the question of, is this the most important discovery in the history of the human species? And that will define geopolitical competition for the next 100 years, that will save potentially millions of lives and, you know, many, many, many other things. And, you know, do we risk, are we putting, like, what is the risk associated with a liability regime of kind of like messing that trajectory up? I'm just curious if you balance that at all.
Yes. So and again, we can get into disputes about, like, so when I talked about these phases of products liability with transformative technologies, I don't think it's that different, you know, like the automobile, which was this thing of danger and leading to carnage, was also seen at the time as revolutionizing everything about society. Mass production of goods, same thing, was revolutionizing. I think the digital age, like namely in the online platform economy, how consumers were receiving things was revolutionary. And so I think that that's appropriately balanced in terms of a risk utility type, you know, test. And I also think it's kind of feeding into my point, at least earlier, about what are the dangers of just saying regulate now, right? We're going to hear about this later, when you could get that horrifically wrong. But also, I don't want to have like a regulatory void and just say there's immunity because it's not, you know, a product. So absolutely. Quick footnote, because I just want to say back to the software question, here's an interesting just data point, right? The FDA regulates software as a medical device. They have guidance, et cetera. That to me is a great example of, like, if you want for underlying reasons to be regulating something because of the medical risks, et cetera, you just do so. Now it's not that easy. We have to get into what's a product, what's a service, et cetera. But we have some examples that are a little more clear-cut. Look just to the FDA. Why are they regulating software as a medical product? And maybe we could get some of that learning over into the tort space.
So looking at the length of the line, which I'm very excited about, and the very limited time we have left in this session, I think one question and then as succinct as we can be, and then I highly encourage you to crowd these panelists after the session and get their thoughts on remaining questions that you have.
Can I just say, like, the accelerationist kind of tendency to focus on long-range risk, one of the things that, and that might be appropriate from a regulatory standpoint, which we'll get in the afternoon panel, but from one of the advantages of the litigation approach, right, the liability approach, is that focuses on actual parties who are harmed in the moment, right, and to say their interests matter too. And so there's a kind of a philosophical, question, a moral question of, should we just say, the injuries to those parties don't matter because of the long-term, like, speculative benefits or, whatnot, or should we actually allow those claims to be litigated? And I think that's one of the values of bringing the courts into the process.
Hi, I'm Chance Goddard, a 2L here and doctoral candidate in information technology. My question is, to what extent can privacy laws impact this products liability analysis for things like failure to warn claims for automated decision-making, as we've seen earlier with AI?
Yeah, I mean, it's a great question. In the places where I've looked at this, like data breach areas, it's back to Chinny's sort of first question of, like, what's the harm and how could it be articulated? And there's been a move because of standing issues with people saying, like, oh, there's something that I don't like about how my data has been released, but I'm not sure how to articulate it as, like, a property. Is that privacy, and the US Supreme Court has said this in some of the standing, since it's this age-old tort, if you can show real privacy harm. So I think it gets my own, very fledgling view. It gets back to Chinny's original question about articulating, privacy harms, the classic Prosser privacy harms, actually, in my view, protect different interests. And there's one that, for example, is like the right of publicity, which would start to interface in some of the things that Katrina was talking about. Then there's like the continental right to be left alone that people still like to talk about, but I don't see a lot of the courts taking that on. So, but it's a great question, and I think a lot more work should be done to, like, update those privacy torts into this new age of digital harms.
Thank you.
Hello, I sometimes taught law to people, and I say their misfortune. And I really enjoyed reading the papers, but I suppose my question is whether you're really sticking with a one-size-fits-all approach to liability, the notion that it's all products, or we could apply a negligence liability rule to all of it. And I guess that my basis for that, it's all biographical, isn't it, autobiographical. I've got a relative who's younger than almost everybody in this room who writes AI programs, even as an intern. And those are programs that are largely used internal to the company he's interning for to get them better information about stuff that they already think they know something about. Now to shift, because it's an AI system, they're now using it's going to be product liability to those that it affects, is actually a big leap from what the current position would be. Now, there might be some situations where the leap's far less, that applying product liability, it's pretty close to probably the liabilities that they'd already have, say a medical device. But it strikes me that there might be some AI systems where the leap is much greater. And so I guess I just wanted to know, are you really sticking with one size fits all? It's all products, or it's all negligence?
So are you concerned that your relative is going to be held liable for the work that they're doing?
Bryan is available for legal advice. I am not.
Well, if you want a real question, that if you're going to say, hey, you need to be insured to be doing this, you do affect whether little startups and the like, how much resources they have to have if they're going to start putting stuff out. And so it does, if you have to have the sort of insurance that you'd need to stand behind a product liability suit, that's a different sort of proposition for some of the little startups that relative might have been involved in. And so I think, it's not a direct concern about liability, but it's a direct concern about, what the consequences are of, what amount of kit you have to participate in this space.
Yeah, thanks for the extra clarification. I'd say, do we compare this to something like nuclear engineering or bridge building or other kinds, or, keeping wild animals? I mean, just what is the nature of the AI risk and the activity? And so is it something where you say, yeah, we want to have anyone, and whether they're trained or not, just mucking around in this, and that's great for innovation? Or do you think we should be more mindful about how we build these systems? And that applies, I think, to software as well. And so I guess it's I don't want to answer that question, but I think there are reasonable minds that can differ on that. But I think that is sort of the core intuition of, should we be allowing anyone to have their hands on this, or should there be some restraint, whether that's imposed by markets or by law or by liability risks, insurance, so forth, right? I mean, how you construct those, I think that's one of the questions.
Very succinctly, let me break this into two questions. The first one, I guess I don't see this as one size fits all. And later in the afternoon, we're going to hear from Eugene Volokh about First Amendment and free expression. So not everything, even though I'm a fan, I'm team products liability, not everything's a product. So some things, there's going to be information expression. So it's not going to be like I'm going out and everything under the sun is a product from now on. But I do think, and I don't think it's such a leap, like I actually think courts are gravitating in the direction, not just the FDA. I agree with you, it's a smaller step maybe for them to deem software a medical product because they've got AI-enabled medical devices. But I mentioned the social media cases of finding design defect there. But on the broader kind of question that Bryan's already answered as well, of this kind of like, it's sort of a philosophical sort of decision about optimal regulation, whether we're thinking about tort liability or regulators. I have a really strong view that the timing matters, and actually we should have liability at the outset. And the worst case scenario, and there are unfortunately some examples of this, are to wait and do nothing and then start to regulate. So think about, for example, direct-to-consumer genetic testing. It was like the Wild West. There was no one regulating, doing anything. And then the FDA decided to treat that as a medical device. And 23andMe, which of course is not the big conglomerate that everyone worried about a few years ago, right? They're in some financial trouble, but nonetheless, what happened was the regulation, when it happened in the middle, ensconced a huge incumbent. 23andMe was the only company then that had FDA approval for what it was doing. So I actually worry more about waiting until we regulate. One other quick example, online platforms, right? Amazon was fighting tooth and nail about being held as a seller, and as soon as the courts started going in that direction, they then got behind legislation that would hold everyone liable, all the small startups of the world, because think about it, they're a huge incumbent that could satisfy the reserves and getting insurance, et cetera. So to me, that all argues for making sure we regulate early enough. And yeah, if you're a small startup, but you might be posing wide-scale risks to society, you should be thinking about liability and insurance, and I think that's a positive thing. But I actually worry more about the do nothing and then start to regulate, because we have antitrust law and other things that we'll talk about actually today too, but we do, the liability regime then really favors incumbents at that time.
So with that, I want to thank all of our panelists and really urge you guys to read the primers. They're excellent. And then read the body of work that these guys have developed over their careers. Thank you so much for your questions. And lunch is in the back. Please get your food, come back and sit down. We will have an excellent conversation with the DOJ Antitrust Director of Policy about antitrust and AI.
So thanks, everyone. I'm Alan Rozenshtein again. I'm from the University of Minnesota Law School and a senior editor at Lawfare and one of the folks organizing this event. I am delighted to have David Lawrence of the Department of Justice here for this lunchtime Q&A, fireside chat. David asked me where the fire is, so I apologize for not providing that. Next year, we can do a little projection.
Yeah, it's a lunch side chat.
That's very good, lunch side. I like that. So David is the policy director for the antitrust division at DOJ. He oversees policy development at the division and supervises its appellate, competition policy and advocacy, and international sections. He served at the antitrust division since 2011 in a variety of roles, including as chief of the competition policy and advocacy section, as counsel to the assistant attorney general, and as the lead of several major civil merger and conduct enforcement matters. I'm really delighted that he's here. Antitrust is such an important part of this story. We weren't able to, unfortunately, there are only so many kind of papers we could commission at one time, and I'm really glad that we have David to sort of talk about something we weren't able to talk about in the papers. So we're going to talk for, I'd say, about 45 minutes or so. David will deliver some sort of brief opening remarks, and then I'll sort of jump in with questions. Then we'll leave some time for questions, same format last time. Paul reminded me of a good rule of thumb for this, which is the first question has to be from a student. So students, start thinking of a good question. Yeah, David, why don't you say a few words?
Yes, okay. Well, thank you so much for the introduction. Really appreciate being here. Wonderful event so far today. Two disclaimers I have to start with. First, I'm speaking in my personal capacity. My views don't necessarily reflect those of the Department of Justice Antitrust Division. Second, the term AI can be really broadly defined. And so just like give me that breadth today, I'll be using it as a general term encompassing everything from advanced algorithmic software, machine learning, up through generative AI and LLMs. And also, I do want to just thank the organizers again for hosting what I think is a critical conversation at a time like this. Academic engagement with the policy community, the academic role of building the blocks of knowledge is so critical to making decisions, and we're in a time when I think regulators and enforcers and courts are going to be making more and more decisions. I think of this a lot like the advent of the automobile. I'm so glad Professor Sharkey mentioned the automobile example. It's really exciting to see this new technology and what it can do. We can hardly imagine how it will change our world. Like, I think people just thought it was going to be faster horses. That's kind of what we're thinking now. But we're also just imagining some of the risks. I also think we should acknowledge, out there in the world today, we accept a great deal of harm from automobiles. But it did also take us many, many years to develop regulatory protocols to minimize that harm to where it is now. So I actually want to set the table, and don't peek at my notes here, with a trivia question.
God.
for my moderator here. Do you know when the Model T was released?
1910s?
You're so close. October 1st, 1908. Anniversary's next week. Okay, another trivia question. What year did Henry Ford get his first driver's license?
You're killing me here. Well, I assume there weren't driver's licenses for a long time, so I'm going to say, I don't know, 1942.
So it was fairly quick. In
really?
Michigan, in 1919, they started issuing driver's licenses. They didn't have a test, though.
Did you just self-certify?
You just asked for a driver's license. And, of course, he didn't live to see the seatbelt laws, which don't come around until 1968. Now, we don't know whether AI will wind up with license requirements for models, what an AI seatbelt is going to look like. But I do hope, and I think these kinds of conversations foster, that we could be a bit faster out of the gate in predicting and preventing the harms, even as we make sure we harness the benefits of the new technology. And so conversations like this are really on the critical path to achieving that. I'm happy to be here, eager to hear your questions.
Excellent, thank you. So let's start with sort of a big picture question. What is the evidence that AI can be used to facilitate collusion? And do you think the law, and specifically sort of competition law, is capable of handling collusion by non-humans? And maybe also just as part of that, maybe say just a little bit for those in the audience who are maybe not super familiar with competition law and these kind of foundational concepts. Can you give us a 30-second overview of competition law as you answer this very other complicated question?
So
I got to get you back to these trivia questions you asked
yes,
me.
I appreciate that. It's a great question. It's a really big question. I'll try to weave in some of the competition law concepts. When you say AI being capable of handling collusion, there's really three kinds of collusion, roughly, that the antitrust laws are often concerned about. So you have price-fixing agreements between companies, and then you have other forms of agreements that aren't quite as bad, like maybe a rule of reason information sharing, which can be problematic. And then you have the kind of collusion that happens in an oligopoly, where the competitors, they don't actually talk to each other, but prices kind of float up because they're like looking at each other and there's only a few of them. So let me just take those one at a time. The first type of collusion, as I mentioned, is this very direct price fixing. And the antitrust laws don't like this because you're fundamentally undermining the competitive process if two companies that purport to be competing with one another are agreeing in a smoke-filled room as to the prices they're going to charge. We treat those as criminal antitrust violations. And in terms of evidence, we actually at the division first came across an algorithmic price fixing case back in 2015. This is the Topkins case. So this case involved sellers in online marketplaces. So you all are probably familiar, when you search for a product in an online marketplace, you get like a bunch of identical products from different sellers with like slightly different prices, none of which end in a 5 or a 0. That's because the sellers are using algorithms behind the scenes, collecting data, and trying to sort of maximize their own position by adjusting the prices, oftentimes in real time. Well, back in 2014, sort of early days of this stuff, a couple of sellers of art posters on a major website noticed that their art posters were like coming up right after each other in the auction or in the results a lot. And so they talked to each other and they agreed to rewrite the code of their algorithms so that they wouldn't bid against each other, which of course is price fixing, raises the prices. And so we pursued that case criminally and the defendant pled guilty. Now, an issue we may soon confront as AI gains capability is what do we do if the humans weren't involved and the AIs had that idea to communicate with each other and reach an agreement? Our answer has been, and I think the answer under the law is, that if a company is delegating this price setting authority to a computer system, it needs to ensure that computer system complies with the same laws a pricing manager would. The Supreme Court's test for what constitutes an agreement between firms in this antitrust context, it's not like contract law, offer acceptance. The phrase is concerted action. And the language is actually really helpful here. So there's a case that relates to the NFL, American Needle, and the Supreme Court said that the law is triggered by conduct that, quote, deprives the marketplace of independent centers of decision-making that competition assumes and demands. And I love that line, independent centers of decision-making. And I think it is readily adaptable to the circumstance where a company delegates its decision-making to a computer system, if and when that happens. I think about it like this. If a regional vice president of pricing in a company, somewhere 6 tiers down the org chart, is delegated authority to set prices in their region, the company needs to train them up on the antitrust laws and make sure they're not talking to their competitors. Because if they do, the law will treat the entire corporation as liable for the actions of that agent. I think by the same token, if a company delegates to an AI to be the center of decision-making on pricing, to be its pricing agent, the company needs to make sure it's training that algorithm not to cross the line into communicating and agreeing with its competitors.
Yeah, so it's interesting. So it sounds like then to think through the antitrust issue here, you have to think through the agency law issue as well, right? And because presumably there's going to be some AI agency. This is another thing we wanted to have a paper on, but we can only have so many papers, unfortunately, right? So there's presumably some work to be done to develop what a agency law of AI is. Like, when does your AI, I forget the funny technical term is, go on a frolic and fancy or something. Someone call out if you know what the actual term. Yeah, frolic and detour. Thank you. Right. And presumably, you could say, right, I have this very complicated AI, and I tried to train it, but these AIs, and they went on a frolic and detour. What do you want from me?
Yeah, absolutely. I think you're thinking in the right space. I would splice it a little thinner that for antitrust law purposes, it's just doctrinally separate from agency law.
Okay.
And it's this concept of concerted action, what qualifies as a combination or conspiracy under the Sherman Act, Section 1. So that's the first type.
So we have price fixing. I think this information sharing was next.
Yeah, so information sharing, this is a second type of collusion where competitors, they aren't agreeing on the prices they're going to charge, but they're sharing a lot of competitively sensitive information with each other. And for many, many years, the Supreme Court has recognized this can be very problematic. It's subject to an analysis where you balance the harms against the benefits, but it's oftentimes illegal for companies to be, like, you think about two rivals like calling each other up and being like, hey, just so you know, next week I'm going to start charging this price. Like, that's a very suspect, oftentimes, competitive behavior. And one thing that's interesting about this, in determining when that's problematic, historically, the courts had looked at how much the information has been aggregated. Like, if it's specific individual competitor information, well, that's really problematic. But if it's aggregated, who could ever tease out what's going on in the market or what particular competitors are doing from that information? It's sort of a factual analysis. You know who can tease it out? AI, right? And so the nature, the economic nature of what competitors can do with information exchanges is changing. And so as we are undertaking our analysis, as we are presenting evidence to the courts, the analysis needs to just keep all of that in mind and keep the market realities in mind. And we have a recent case, talking about evidence that's in this vein, or a related vein, which is a lawsuit we filed just a few weeks ago against a company called RealPage. And I want to respect the court, so I won't go beyond the pleadings. But the basic allegation in RealPage is that the software company sells a software, advertises a service to landlords, where the landlords provide their confidential pricing and apartment information to this software company. The software company runs an algorithm, and then it tells the landlords how much to charge for each unit in real time. And it's doing this for, as alleged in our complaint, competing landlords. And we allege that this raises prices for rent and creates a problem. And I won't go beyond the case further than that, but you could look to we have a fairly lengthy complaint. You could look at some of the details.
Yeah, I will say, because I can go further. Does RealPage not have lawyers? I mean, that sounds really bad, but fair enough. The third example he calls oligopolistic collusion.
Yes,
Say
so
that
this
three
is
times.
more than oligopoly behavior. They actually have even more technical terms for it in antitrust: parallel accommodating conduct and tacit coordination. But what that is is when there's two gas stations across the street from each other, the owner of one doesn't have to walk across the street and talk to the other one for the two of them to look at each other's signs and kind of nudge the price up, and vice versa, right? If both of them are charging $3.50 a gallon, the one guy on one side of the street knows if he goes and puts it down to $3.40, the guy across the street is probably going to do it too, right? So, but if you're at an intersection with like 12 gas stations, that doesn't happen, right? So that's what we call an oligopoly, a market where it's fairly concentrated. There's not a lot of different competitors, and they're able to engage in this kind of coordination. Now, the reason I use the gas station example, really easy to see each other's prices. So historically, in our merger law, right, when we were looking at what the risk if two companies are merging, the risk that it's going to result in some of this oligopoly coordination, one thing we'd look to is how transparent are the prices? How easy is it to see and adjust your pricing? Like how much is it, like the gas station example? This is another area that AI is changing because it's fairly common now for companies to have AI systems that are just actively determining and using the web all of their competitors' prices. And so you're able to have that oligopoly pricing problem with relatively more competitors in a market. And so one way we've reacted to this is something that last year we revised our merger guidelines. We have a guidance document about how we review mergers, have revised it every 10 or 15 years, put it out for public comment, and a lot of people raised this concern. So we added some discussion in the section on this issue that if people are using algorithmic pricing tools, that we're going to be more concerned about oligopoly coordination.
So we've talked so far then about how AI tools themselves can be used to potentially cause, maybe intentionally, even maybe unintentionally, right? Because you can imagine, in good faith, I made this algorithmic pricing tool, and the AI just was smarter than me, right? And you have to figure out how to deal with that liability.
Yeah, so just to go back to my example, in good faith, I hired a sharp regional manager for Texas, but I forgot to train him not to talk to his competitors, and it's actually really profitable to talk to your competitors. So if you don't train people not to do it, they're gonna.
But I want to move now to the question of potential anti-competitive issues within the AI industry itself. So one thing that's just really remarkable about, especially sort of the frontier of machine learning, is how concentrated it is because compute scale, and data scale, is so important, and that it's just hard to make progress unless you have a market capitalization of $100 billion, and there aren't that many companies that do this. So given that concentration, how do you think about the potential antitrust problems, right, generally? And then, speaking of mergers, when it comes to the acquisition of, let's say, AI startups by the large incumbent players. And we've seen a lot of that as, a lot of the really promising AI startups that popped up in the last couple of years, they get out of the gate, they make a really impressive product, and then they want to scale to that next level, and they just don't have the money, they don't have the cloud compute. So, they end up being bought by Microsoft or Google or Meta or something like that.
So let me, sort of weaving in the antitrust 101 pieces here, let me start with why the benefits of competition are so important in this industry. So this is 101, but competition is the foundation of our economy. It's how it works. Right? We have a capitalist democracy. And the way that works is when rivals compete, whether that be in foundation models or chips or app, they deliver people that they do business with more of what those people want and less of what those people don't want. So my boss, Assistant Attorney General Cantor, he likes to say that competition is beautifully democratic in that way. I very much agree with that. When we talk about being a capitalist democracy, it's because those two concepts are kindred spirits, right? The people have the choice in our economy. In contrast, when dominant firms control markets and engage in exclusionary behavior, markets become less responsive to the things that people want, and the exclusionary behavior can stifle innovation and entrepreneurship. So if there's a dominant gatekeeper keeping small firms out of the market, that's one of the things we're focused on in the monopolization case, you're less likely to invest in a startup in the first place because you perceive that threat and you're not going to be able to enter, right? And that competitive dynamic is so important for much more than the price of gasoline, or other services. Because, AI is a great example of this. I don't know, like sitting here in DC as a bureaucrat, what consumers will want to see in their AI products. I can guess they will want them to be safe, secure, accurate. Those things we think about, regulation may be addressing. But the very best regulator to ensure that people are getting what they want is going to be that competitive process out there in the free market, driving companies to respond to consumer demands for safety and quality of products. And just to go back to my automobile example, there are many lives saved every year because of competition between auto manufacturers over and above the regulatory floor. You think about differentiated companies like a Volvo that are like advertising the safety, right? But we need competition to have that dynamic playing out in this ecosystem. And there's also, I think, in AI and in a lot of industries, areas where there are market failures, and you find regulation necessary beyond relying on the competitive process. Experience has proven that the more competitive markets with multiple firms are easier and more effective to regulate because monopolists tend to capture and sort of pretty readily defy the will of their regulators. We went through this with AT&T when it had a telephone monopoly throughout the United States. Okay, so that didn't answer your question, but that's sort of the backdrop. It's an important backdrop because, when we look at dominant players in any ecosystem, we are very focused on ensuring they don't leverage the dominance they have today to exclude competition tomorrow. And you see that principle in we now have a number of monopolization cases pending, several of them in the big tech space. There's a case in federal court right now against Google. We just won a monopolization case against Google related to search. We have cases against Visa, Ticketmaster, and Apple now. And you'll sort of see across those a concern with how dominant firms have an incentive to exclude competition and build moats around their castles. But when they do that, they frustrate the competitive process, they make the markets less dynamic, and that's problematic in the long run. So that's what we're looking for and looking to try to prevent.
Sure. So relatedly to this concern about monopolization because of the need to scale compute is this question of data, right? So data is, I don't know, after compute or with compute is sort of the most important resource here. And so how do you view data as sort of a special part of the antitrust analysis here, whether it's data accumulation or data sharing?
So I think this really, it goes back to what I was just saying, and I'm going to keep hitting the gas stations for you. It doesn't matter how many gas stations are on the street. If one of them bought like all of the gasoline in the world, they would be able to just shut down all the competition locally, right? And so one thing we're looking for in markets, and I'm not in a position to say it's a fact inquiry, like how data exactly will play in specific AI cases, but what we'll be looking for is the extent to which it's an important input to competition among all the rivals, and then whether and how it's being used or abused to exclude competition in the way that we think is problematic.
So another aspect of potentially anti-competitive conduct is vertical integration, right? So you have horizontal integration, right? You have there's only one gas station, right? Or someone controls all the gas stations in an area, but then you have vertical integration, they control the gas station, and they control the refinery, and they control the oil well, et cetera, et cetera. We're beginning to potentially see some of that in AI, right? Whether it's NVIDIA, which obviously makes all of, most of the high-end chips, maybe releasing its own models. Sam Altman, right, head of OpenAI, going around, at least reporting suggests, and trying to, raise literally trillions of dollars for chips. Honestly, with the news that Microsoft is going to buy all the energy from the 3 Mile Island reactor, maybe these companies are also going to become fusion companies as well to power their stuff. So you're seeing potential for vertical integration. Does that, again, without commenting on any sort of specific situation, does that raise its own special set of potential antitrust concerns, right? Apart entirely from kind of horizontal integration?
So the analysis is different from the horizontal integration analysis. And I'll be careful to just stay away from any particular firms. Our merger guidelines that we just updated talk about this. And I actually, I'm going to start with the example you gave is a company using its own R&D and investment building a vertically related product or service, right? So if the gas station owner like bought some land down the street and built a refinery, right? And what our merger guidelines say is that tends not to be problematic. We want companies to invest and innovate, right? There's a different analysis if it is purchased through acquisition as opposed to investment. And that's where, I alluded to this earlier, then you're going to analyze whether that merger, it may have some benefits related to the vertical integration, but there's also potentially relationships with your rivals that the company you're buying already has. And that's where we're going to look for sort of the competitive effects. And I'd contrast that again, if a company's just building its own new product or service, we're not going to be concerned that rivals are like reliant on that product or service. It didn't exist yesterday, right? On the other hand, if you're buying a product or service, the phrasing in the merger guidelines is products your rivals use to compete. So if yesterday they're using that refinery, now you're buying it through acquisition, now we're going to need to worry about whether the merger is going to harm competition in that way. And then a similar analysis can sort of play out with contracts. It's not uncommon for there to be vertical contracts that are locking up key inputs or distribution channels. I think I mentioned a minute ago this Google search case. So we just won a liability judgment in DDC where the court agreed with the United States that Google is a monopolist in search and that one of the ways it maintained this monopoly was by paying a bunch of phone manufacturers so that it has the default status on the phone. So I think one of the findings of the court was the payment to Apple from Google to be the sort of lead search is in many billions of dollars, right? And in those situations, the competitive concern arises that you're limiting opportunities for competitors to maintain your dominance.
One of the major, I don't know if fault lines is the right word, but one of the major kind of buckets of the big frontier models is whether they're closed or open, right? And there are lots of definitions of what this means, right? But you can say kind of a first approximation, you have models like the GPT family of models of OpenAI, the Claude models from Anthropic, Gemini models from Google. They're closed in the sense that we don't know the data that went into them, we don't know the algorithms, we don't know the weights and biases, right? The specific parameters of all of this stuff. And then you have, on the other hand, open source model. You have a bunch of them. Obviously, the most important one probably is Meta's Llama model, which is always like 2 months behind the frontier, but sort of pretty clear that at this point, you can have open source models that are basically as powerful. And I think maybe Meta, I think earlier this week even released some updates to that. So I guess my intuition would be that open source models present fewer antitrust concerns, but at the same time, who knows why, and again, abstracting from the specific case, right? But who knows why a company like Meta, right, would do an open source model? What's in it for them? So maybe open source models aren't better for antitrust. I find myself sort of quickly getting into knots about this open source. I like open source sort of for my own ideological reasons. So I want open source to always be the answer. But I'm curious what you think about sort of how the open sourceness of a model would play into the analysis of competition. Now, of course, so I should also clarify, if you use the open source model to yourself, it doesn't matter, right? You include the closed source, open source, it's probably not going to help you. But when you're thinking about anti-competitive issues within the AI industry itself, is open source better?
I want to caution our cases are fact specific, and you get into the details on each one. But maybe I'll mention, some features of open source that are attractive from a competition standpoint. So if the most important thing in competition is that we encourage dynamism and innovation, that the market's able to move quickly and people are able to get involved, open source has some attractive characteristics. One thing I'll mention, this is an economic concept, but a lot of these markets are characterized by scale economies and network effects. And there's probably some aspects of the AI stack, some important ones, where we'll see those economic features. Network effects is like the larger the network gets, the better it is for every participant. You see this in like apps and things like this. Network effects can play out on a firm level, or they can play out on a market level. Right? Think about the network effects in email, right? Lots of different providers, but we have market level network effects because you have interoperability, and it's just an open connection between email. And the web could have developed differently. Like, we could have seen somebody shut the walls of email and just taken it over because they deprive rivals of the network effects. So open source is a great model to try to capture some of those broader network effects. I also think that that open source, it can be attractive for some of the other features that a lot of folks are focused on around the development of AI, especially safety and security, because open source. So we had a conference a few months ago. We went out to Stanford and co-hosted with them a sort of AI workshop. And the terrific thing about that is we got like VCs and founders who would never fly to Washington, D.C. to talk to us, to like take the quick cab in and talk to us for 45 minutes, right? And we actually heard from a couple people who were developing, they're not developing models themselves, but they're hoping to be the player who's the third party who helps facilitate in an open source ecosystem safety and security for the various players in that system, right? And so the same thing in the academic community. The more open these models are, the more capable academics are going to be to get in there, look for vulnerabilities, and try to expose them. Now, of course, you do get into on the safety and security side, like who are the users, right? And so one of the conversations that's playing out there, and get back to my trivia question, how long did it take Henry Ford to get a driver's license, is you could see, and I think the conversation will play out, over whether open source, when it's significantly powerful models, sufficiently powerful weights, whatever it might be, that there's a sort of licensing requirement for those developers who access it, and then maybe the apps the users develop don't need those licenses. You know, far be it for me to say, but it's a conversation that I think it's going to be really interesting to watch play out.
Yeah. So since you mentioned sort of the internet and you mentioned the Model T trivia questions, let me ask about sort of the history here a little bit. Are there any lessons from past technological revolutions that you're thinking about when, and DOJ is thinking about generally, when trying to apply the antitrust law to AI? And let me give you a more concrete example. So, you know, the internet was a big deal, and it developed, and obviously it's not as if antitrust cases weren't brought. I mean, the big Microsoft case was specifically about Internet Explorer and all that sort of stuff. But there, I think, is a perception, I think it's reasonably fair, that it was pretty light touch. Like, if you look sort of in aggregate of the government's regulation of the internet, whether through antitrust or other ways, it was pretty light touch. Now, you can think that was a really good thing, you think that's a really bad thing, right? But putting that aside, I'm curious if, you know, how you're thinking about whether or not it should be or will be or can be similarly light touch when it comes to AI. Or to, you know, going back to your kind of trivia questions, whether you think it would be a bad thing if we just let this develop in its own way for a decade or two and then see where we are.
I think that one of the lessons of the evolution of digital markets, where I think it was fairly light touch early on, it was light touch early on in the hopes that competitive forces would come in and bring new competition to some of the dominant players as they were emerging. And, you know, I mentioned the network effects. There's some really powerful economic principles at play in some of these markets that proved us wrong, and that led dominant firms to be able to maintain their dominance, and we saw some durableness to it. And so I do think that one of the takeaways from that, and you hear this from law enforcers, from state attorneys general, is that doesn't mean we should just go bring cases in any particular area, but there had been a philosophy in the past that, we should just sort of intentionally stand by, even if the law is technically violated. And I think the philosophy now is much more, we should fairly examine the facts, examine the law, and bring those cases without fear or favor whenever they appear.
And in doing that, how do you think about balancing the need to enforce the competition laws with the desire to keep this industry innovating, right? Because, you know, you could imagine, you know, folks in the industry being worried about what they would view as over-aggressive antitrust enforcement, because they might say, look, this is a unique market in which scale is everything. Like, it's all about scale. So, you know, we appreciate the competition concerns, but like, you just can't build GPT-7 unless you have a market cap of trillions of dollars, and that means there are going to be only very few of them.
Yeah.
These companies, or we need to make it very easy for these companies to buy startups,
Yeah.
because that's just only going to be the way that a startup comes up with a good idea, then they need to scale that up, right? The only way that's going to happen is if Meta buys them. So if you guys are really stingy, right? Let's say with your merger acquisition rules, that's great. We're gonna have a very competitive market of not great models, right? So how do you balance that?
So maybe I'll just
And maybe it's a false dichotomy, right?
yeah, I'll
Feel free to push back against the framing.
quickly push back against the
Yeah,
last
yeah.
framing. So if you're an entrepreneur looking for exit and you have multiple billion-dollar valuations, there's going to be more than just firms that already have dominant monopoly power in a local market who are interested in buying you, for the most part, right? And maybe that second place bid, because the company doesn't have monopoly power to preserve, is 10% lower. But you're going to continue to see, I think, those exits taking place. Going back to your broader question, historical examples, I think, are really useful in times like this. And so I have a paper in the Network Law Review focusing on the development of the telecommunications industry and the sort of interactions there and what we can learn. And one great example is the AT&T breakup in the early 1980s, which I think ushered in enormous innovation in and around telephony, both long distance and then the rise of the cellular networks. I won't ask you a trivia question about the first cell phone, but the first cell phone was the Carter phone. It was this rancher, his name was Carter, and he, not Jimmy, and he wanted to be able to be out on his ranch and still take phone calls. And so he essentially, this is like in the 60s, he essentially strapped like a walkie-talkie to his phone at home, and then he like did some 60s era circuitry, and he made this device so he could be out on the ranch, right? And it was really a great invention, right? Like cell phones are super good. So he wanted to bring it to market. AT&T had rules. And AT&T had rules that nobody could make a device that attaches to the AT&T network without AT&T's approval. So they shut that thing down. And he litigated, he went to the FCC, and it took, I think, 10 or 15 years for a government order to say, like, oh, AT&T, you have to let the Carter phone happen. Meanwhile, 1983, the government breaks up the AT&T monopoly. You wind up with local telephone companies, and this is key. Each of those local telephone companies winds up building its own cellular network. And you have multiple cellular competitors in the United States. And the guy who, like, more brilliant probably than Carter, Steve Jobs, comes up with an even new great type of cell phone, right, the iPhone, and we all know that origin story. He like talked to cell phone companies, and AT&T, no longer a monopolist, but facing competition from 3 other cell phone providers in the United States, gave him like one of the biggest sweetheart deals ever given to a phone manufacturer, rebuilt parts of its network, remade the data plans so that it could advertise, compete, by saying, come to our network, you can get the iPhone, right? What a beautiful innovation story. And so I bring up that historical example because I absolutely reject the premise that you need monopolists to drive innovation. Innovators thrive on competition, the availability to get market access, the ability to get new partners and to go out there and compete. And so I think that's something we really need to support.
So far we've largely talked in the domestic context, which makes sense, right? That's, competition law is mostly domestic, most of what you do is domestic, but not in all of what you do is domestic, and you are the head, in addition of policy and appellate, the international side of the House. And so I'm just curious, how much of this is an international story? It is true that most of the frontier labs are in the United States, but certainly not all of them are. Mistral is kind of the French lab, and they're very close behind. Obviously, you have a lot of stuff happening in China. It's a little delayed because of export restrictions and stuff like that. And then, of course, even the U.S. labs have their international outposts. A lot of the Google stuff happens in England. So I'm just curious, to what extent is there an international component, and what is it, and sort of how do you think about that for AI antitrust?
Sure. Great question. I think there's a significant international component to the policy dialogue around AI. And just for background, international antitrust enforcers like international enforcers who have like overlapping jurisdiction in a lot of areas, that get together for policy discussions. Like next week, the G7 competition summit is happening. So the senior competition folks from the G7 countries will get together. The 2 days of that summit are focused on AI. And it's in part just because everybody's doing what we're doing at this conference, which is trying to learn and get smart. And as a policy worker in an enforcement agency, and I think you know this, you have policy experience, you want to be learning from you're reading the academic articles, you're reading the white paper articles. Other law enforcers who are thinking really hard about it have a uniquely valuable perspective. There's something so useful about just like stepping out of your own day-to-day, and they have a different country, but some of the same issues interacting, and just being able to like think about it from another angle, like you come back home and I think you approach it a little bit smarter.
So I want to finish, I'm going to ask a last couple of questions before we go to Q&A, so folks should just start thinking about their questions.
Do you have trivia for me?
I don't. I'll leave it to the audience. I want to end by asking a couple of questions about sort of the more nuts and bolts of DOJ's role here and sort of the capacity that you have to do this work. And one question is, as you're thinking about these, as you're bringing cases, do you feel like you have the legal tools to do the kind of work that you need to do here? So this is a law and tech conference, so I am legally and contractually obligated to mention the Judge Frank Easterbrook's Law of the Horse article from the mid-1990s, right? This is this question that is sort of ever present in tech law circles about whether this is all completely new and we need to like utterly come up with new legal concepts and legal rules and statutes and stuff like this for some new technology, or if this is interesting, right? But we have background principles of whether it's products liability or negligence or IP or antitrust that are perfectly good here. And just like you wouldn't have a law of the horse, right? You just have law of normal stuff that you apply to horses. And so you might say, look, we have the Sherman antitrust law, right? We have these statutes. It's kind of nice that they're incredibly short because we can interpret them capaciously, and that's fine for AI. Or you might think, we just need new tools, right? We need to go to Congress and we need new statutes because there's some unique challenges here. So I'm just kind of curious if you could riff on that, that idea.
Sure, I would distinguish maybe between whether the tools in the law are important and whether they're sufficient. So, as I think maybe this conversation has underscored, and this is my day job, there are very important respects in which the existing antitrust laws engage with the emerging AI ecosystem. And it's really important, and case-specific adjudication and the existing cases are going to engage importantly, and we just need to take those one at a time. There's enough to do there for me that I don't have to sort of take on the question that we leave to Congress of are they sufficient, or we leave to state legislators. Are there gaps beyond that in the law? I kind of focus on the law enforcement day job, so I don't have to worry about it.
Fair enough. A big part of bringing these cases is having the technical expertise to know what is going on with these models. And that technical expertise is very hard to come by. I mean, it's hard enough for the frontier labs to hire, machine learning engineers. I imagine for a number of reasons, and this is a kind of a standard problem in government, hiring really good subject matter experts in technology is difficult. What is antitrust's needs in having this kind of in-house expertise, and how has that process been going to get that?
So it's such a great and important question. I mentioned the international community. This is going on all over the world. The Competition and Markets Authority in the UK, they built their own digital analysis, let's bring on technologists unit, and then hosted a conference for other agencies to talk about how to do it. We've come a really long way. So take you back about 5 years. I was actually at another agency. Quick story, but kind of funny. The first time I encountered a really big machine learning piece of evidence. So a white paper comes in from the party trying to establish a proposition that is relevant based on they had millions of cell phone data pings, and they put them all into a giant model, and things occurred, and then out popped a number favorable to their client. And so, my job as the regulator is I was well, can you give me the black box? So they did. They sent the hard drives. There was an evening at that agency where everybody lost access to email for about 15 minutes because they tried to put those hard drives into the system. So we wound up having to hire a consultant and figure out a way, and it took us months to just peer inside that black box and kind of fumble around a little bit.
This reminds me of that scene in Zoolander, the movie, right there. It goes, the answer is inside the computer. I can just imagine
Yeah.
someone sending you a hard drive. That's the
Oh,
model.
yeah,
That's
you
the
know.
black box. Enjoy.
You're talking to the consultant come in and they're like, oh, trust the black box, number comes out good, believe us. Yeah. So we need to be able to examine these things, right? At the same time, we can't be afraid of the fact that some of these exercises can be really helpful to answer questions that are important that we didn't used to have good answers to. So AAG Cantor, the day he arrived, when he was talking through key elements of his vision, one of them was we need to bring on experts beyond lawyers and economists. So we previously were staffed it with just lawyers and economists. He changed the name of our economic analysis team to the expert analysis team and started hiring data scientists, machine learning experts, technologists, people who would help us with these issues. And I don't mean to suggest we've solved it, but in the various cases I've just mentioned, those people were kind of critical to at least start to peer inside of the black boxes.
Great. And then last question before we go to Q&A. So we've been focusing, for obvious reasons, given that we were very lucky to have you come here, on DOJ's role in competition and antitrust. But of course, DOJ is not the only player here. At the federal level, antitrust enforcement is split in interesting ways between DOJ and FTC. And then, of course, we haven't talked at all about the states, which play an extremely important role in antitrust, often on their own initiative, often in collaboration with the federal government. And there's, my home state of Minnesota, right, has, I think, one of the more aggressive sort of state antitrust practices, which I think is kind of neat. So how do you think about DOJ's role? How is DOJ thinking about its role in relation to, other partners or, I don't know, frenemies maybe? I'm sure it's very complicated, all this jurisdiction.
No, but I'll pick between those words. I mean, it's partners,
Yeah.
right? You have multiple law enforcers. First of all, we're all very resource constrained. And so having more hands working on issues, having situations where you can divide up even pieces of a case or something. So we work closely with our state attorneys general partners, jointly. And actually, each of the cases I mentioned today had multiple state attorneys general, in most cases bipartisan, signed on and helping us as part of the investigative team. So they're really helpful just from a spreading the resources perspective, and the same with the FTC, right? So they take a significant portion of the cases, we take a significant portion of the cases. But then I also mentioned this critical exercise, especially in emerging markets, of getting smart, being thoughtful. The kind of debate we can have with an enforcement partner, you can be, we'll have a confidentiality waiver in place. You can really talk issues through and leverage each other's expertise in a way that I think is just really helpful and is good government.
So I invite folks from the audience to ask questions. Oh, yeah, we do need to start. We should start with the student. Excellent. Yes, we will start with the student. Thank you.
Perfect. Okay. Hi, my name is Skylar. I'm a 1L
Hi.
at Georgetown Law.
Nice to meet you.
My question is about retail platforms and how their algorithm plays into the test of collusion, because I was thinking they're kind of between oligopoly and information sharing, but on the other hand, they're not explicitly sharing their algorithmic recommendations to the sellers, but in a way they're kind of participating in this one system. And the delegation, they're not really, the sellers aren't really delegating their price choices to retail platforms either, but they get so much information from the other sellers that are on the platform.
It's a really great question. So the question is about retail platforms and the way they use their algorithms. As I'm going to give the answer I've given a few times, which is these things are really specific. And I wouldn't want to just give a general answer. Talking about partnerships, the FTC has it's in court now, lawsuit against Amazon that discusses a lot of very specific behaviors with the operation of the platform. So you might sort of look to that for more detail. Thank you.
Hi, also a student, so.
Thank you.
So I just want to go back a little bit on open source, and so if I understood you correctly, open source is encouraging pro-competitiveness in one side. And then we also have the risks of safety, as you also mentioned. And I want to know, like, your thoughts on, like, I don't know, like this type of tactics that might be going on about, like, maybe open source first and then closed later. You know, like I'm bringing how that brings or shrinks the market. And also in that same line, your thoughts on like maybe having regulation are also shrinking the market if you closed, you know, like if you put regulation on top of this type of industry where you're in some sense shrinking the market for open source type of business models in AI.
Yeah, so a couple pieces there, great question. I think that when we think about constructing regulation, to the extent regulation is necessary, it's critical that regulatory agencies be thinking about competition and that they not be regulating in a way that erects barriers to entry and limits the competitive dynamic. Actually, in this administration, President Biden put out an executive order early on calling for a whole-of-government approach to competition and creating a competition council at which we and FTC and various federal agencies that have regulatory authorities like get together and focus on the competition side of this. Relatedly, actually, OIRA, this is getting into the regulatory weeds, but they have a circular that requires cost-benefit analysis, and they added an additional, I forget if it's called a supplement or a report, specifically instructing agencies how they can examine the competitive implications of regulations. This is incredibly important to do because as long as there have been monopolies, there have been monopolies advocating to government to create regulations that would create barriers to entry and preserve their monopolies. And so regulators just need to be really on the ball when they're examining regulatory frameworks to make sure that they're achieving necessary ends in the least anti-competitive way, in the way that sort of least protects just the dominant firms.
I'm going to use moderator's privilege to actually ask a follow-up, because I'm going to ask the kind of converse or contrapositive, I always forget which of those words is correct, of your point that everyone has to think about competition. And my question is, what other than competition does antitrust have to think about? So one thing I liked about this question was, that the student asked, so thank you for it, was this point that, you know, maybe open source is really good, and let's just hypothesize for a second, that open source is really good for competition, but on margin, it's not so good for AI safety, right? I'll be very clear, I'm not sure that's true, but let's just assume it's a plausible first approximation. When antitrust thinks about, okay, what's it going to do, does it say, okay, look, our job is competition. That's what we do, right? It's not our job in the first instance to think about safety. Like, there's an AI Safety Institute at NIST in Commerce. That's their job. Or does antitrust, when it thinks about these issues, have to say, yeah, we do competition, but at the end of the day, we have to think of all of these considerations.
Yeah. So, really great and important question. I'm going to get back into like antitrust doctrine. So, in most of our cases, like these monopolization cases, first we show why it's harmful to competition. And at that point, all we're thinking about is competition. And then the defendants can try to establish that there are sort of legitimate business justifications for the conduct.
And or maybe social justification. So maybe it has to be closed because it's safer or something.
So if safety is legitimately part of the justification, I would think something like safety is really, you know, in many cases is going to be part of the competitive analysis too. The question though is whether there are legitimate justifications or whether they're pretextual. And so, you know, that's a very fact-bound analysis. I'll, you know, bring up our old friend, the AT&T divestiture. In the years leading up to that, you can look up the papers, monopolist AT&T advocated loudly and vociferously on the Hill, at the White House, and in the public sphere that them maintaining their telephone monopoly was critical to maintaining our nation's security against Russia. And that if this breakup happened, the Cold War was threatened. Now, in that particular case, the Cold War went our way and the breakup did happen. But in the other cases, we're just going to look at the facts and really get into it in order to determine whether the justifications are legitimate.
I did not know, but that's great. I'm going to go reread those. That must be fun to read in retrospect. Please.
Hi, my name is Mayu. I'm a fellow at EPIC. And I think one of the more frustrating sort of like setups that we see in terms of privacy and consumer protection is when a consumer is using a product not because they chose it, but because like they work at a company or they go to school and like that's the email that you're supposed to use, or like whatever product that they're supposed to use, and they don't have a choice in it. And so a lot of times I think like the competition in that space can be misaligned in terms of like, it might, I don't know, like an email company might be competing based on like what the employer wants to do, which might not be privacy protective. And so like as an employee or like as a consumer, you don't get a choice in it, and you don't feel like the companies are competing to protect your privacy. And so I'm just wondering, like, what are kind of like, are there antitrust like frameworks that could help, or are there other solutions where, I don't know, do people have to get together and be like, this email sucks?
So there can be antitrust implications when these third parties are involved, and particularly if they're being paid to make the decision. So I mentioned like the Google search case, where the default search engine on everybody's phones is like Google is paying the phone company to make that happen, right? In terms of your specific email, I'm not sure, but these issues can arise. Thank you.
Hi, my name is Jack. I'm a researcher at the Center for Security and Emerging Technology here at Georgetown. Wanted to go back to some of the discussion we were having on vertical integration in the AI supply chain. I think a lot of the discussion has focused on like the need for cloud computing and kind of all of these different inputs that are required to build foundation models in these kinds of AI systems. I'm curious though if you guys have been thinking about kind of like the other side of it, the distribution side, because it seems like a lot of these companies that are very well resourced on the computing side also have a lot of other software products that these models could potentially be integrated into, and there seems to be a lot of opportunities for self-preferencing and that sort of thing. So I'd just be curious, like from your perspective, what sorts of behaviors are you guys looking out for?
Outstanding question, and absolutely. So I'm sure there's been discussion today. You have multiple layers in this AI stack, and you'd be looking, all else equal, each layer would be trying to encourage competition in the corresponding layers, because if there's a dominant firm in a corresponding layer, they're going to be like sapping the rents on either side. But you can have contracts or mergers and acquisitions that sort of like pass the dominant firm's incentives like to the other layers to sort of restrain that sort of competitive force and to limit competition. So we would be looking to anywhere in the stack that somebody's operating as a gatekeeper, that they have significant market power or monopoly power, and then asking the question of whether there are specific behaviors that are leveraging or maintaining it anti-competitively. Yeah.
Hey, my name's Carrie. This has been so interesting. I litigate cases against big tech for product liability and distributor negligence, and I'm really interested in the idea of data sets that are not open source but are actually obtained through the discovery process of litigation, and then rich resource parties then try to swoop in and get it. So for instance, and what the regulation should be and the privacy issue should be around that. I happen to be in possession of like 60,000 items from a shuttered website that I litigated against. Let's call it Omegle. And like a third party has offered to purchase that. And it's a third party that's interested in child welfare for big tech, and they don't share with each other because they're competitors with each other, but think that a data set would help all of them if it comes from a third party. But I think it's kind of unethical, and there are privacy implications because data sets have names and addresses and emails and trauma in these types of reports. So what do you think?
So in my world, because we're the federal government, we have a lot of restrictions on the sorts of things. So one answer is I don't have to think a lot about that because we are very heavily restricted in that way. My instinct is like a case management order or the orders of the court might have something to say about when and whether that's happening, but I guess the details could be case specific. Thank you.
Hey there, my name is Adam. I'm with Encode Justice. We're a youth advocacy organization focused on AI. One of our student volunteers is actually writing a brief on Real Pages. So I was sitting there editing it, and then you started talking about it. So I was like, oh, this is cool.
Oh, wonderful. No, nice to meet you.
And I think the crux of that case is that there's basically a perfect intermediary that's getting all of the information from all of the different parties. And so, X party and Y party aren't necessarily seeing each other's private information, but this intermediary is. It's like if all of the 10 gas stations had a guy named Bob that was like getting all of their rental information and their insurance, is there, existing context for that with, an individual like Bob that's an actual human in the past, or is this a completely novel thing, not just because it's machines, but because we haven't had an intermediary in that way?
So there are, I don't know if they were named Bob, but there have been a number of cases over the years, like if multiple competitors agree to have somebody else like set the prices market-wide, that ringleader and the agreeing parties could be held responsible. Yeah. And actually, perhaps an analogous example relates to ebook pricing. So the department brought a case when the iPad launched. Apple worked with we alleged, and the court agreed, that Apple worked with a number of publishers to set a new pricing protocol market-wide for the sale of ebooks that was less favorable for consumers than what was already happening off of the iPad. And so we challenged that and with all of the participants around the conspiracy as well.
Interesting. Thanks.
Thank you.
Well, I think this is a good place to end it. I hope you'll all join me by thanking David for extremely interesting conversation.
We are not about 9 panels and 18 hours. This was a highly efficient conference, but I also love how engaging all the conversations have been. For those who missed my intro in the morning, I'm Paul Ohm. I'm a member of this faculty. I had nothing to do. This is not me saying I'm not to be blamed. I had nothing to do with the writings, and I'm sad because they're really wonderful, and I wish I had been invited to author. No, I'm just kidding.
Anytime, man. You know my email address.
Exactly. So our final panel is Eugene Volokh from UCLA, who's written a paper on the First Amendment and artificial intelligence. Oh, my, yeah, you're not UCLA anymore. Stanford and Hoover. My goodness. And then Chini Sharma and Alan Rozenshtein, who you've heard from before today. And they've written a piece about kind of the regulatory state and its role. In a sense, right, these are kind of 2 papers that are a little different from one another, but I actually think, and maybe this is just post hoc rationalization to make this panel make sense, that it actually, in a way, the first panel was a cleaner set of traditional kind of thing, damages thing, right, precedents, or in the case of copyright infringement. And here, I think we're going to dip a little bit more into structural problems, big ticket problems, and probably with liability at its center, think about how do we just make sure these AI systems have benefits and not too many harms, right? As far as the legal system can accomplish that. I am not quite as skilled as Chini to ask questions about both papers simultaneously. And so what I'm going to do in the beginning is a little bit of tennis, where I'm going to ask a question of Eugene and then a question of the regulatory paper authors. I also love, my favorite scene in my favorite movie is Spinal Tap, when they're on the back end of their career and they're not even the headliners, they're the second to a puppet show in a carnival. And in the beginning of it, they're just like, this is the new Spinal Tap, a free-form jazz odyssey. So I want this panel to become a free-form jazz odyssey. So you are all deputized to be co-moderators.
Can we turn it up to 11? This panel goes to 11.
This goes to 11 with a tiny little stone hedge. If you're in Gen Z and have no idea what we're talking about, that's why.
Run, do not walk, and watch Spinal Tap.
Yeah. And so I want you all to engage with one another, partly because I think everyone on here knows a lot about the First Amendment. Everyone on here knows a lot about the regulatory state. Okay. So without further ado, Eugene, I didn't embarrass you with your full biography. I think the most important line in your biography is taught Paul Ohm everything he knows about copyright law. That's really...
It's everything I know, but you know much more about it now.
No, but from that moment, one thing that really has stuck with me about the early part of your career is your now landmark paper, Cheap Speech and What It Will Do, and how it kind of, in a really prescient way, anticipated social media and anticipated some of what happened with smartphones with a First Amendment lens. And so now I'm curious, like, have you written, are you thinking about cheap speech 2 or automated cheap speech and what it will do? So maybe for the benefit of the students who may not know this piece, talk about your observation then and what it might do to the First Amendment law, but I want you to try and map that onto large language models or
Sure.
other forms of AI. Yeah.
So back in 1995, I was invited to do a paper on the internet. Now, I knew a little bit about the internet. Just at that point, it was basically email and some really non-graphical browsers. But my view was the internet made actually the promise of free speech and in particular freedom of the press actually available to people. It was a mechanism through which people, both large organizations of people and small individual people, could much more effectively speak to each other. And even if the technology was nascent, you could really see the writing on the wall, and that it would enable things like Substacks, like electronic delivery of books, and a variety of other such things. Of course, enabling everybody to speak where before they had to be rich or connected to speak effectively to the public has pluses as well as minuses, because all speech has pluses as well as minuses. But it was pretty clear what was going on is this is just another mechanism through which people can more effectively speak. It's not so clear with AI, right? It's a mechanism through which speech is now generated in a way that both the authors of the software and the authors of the prompt cannot fully anticipate. So this does raise, I think, new issues of speech protection in a way that the internet did not really raise. I mean, to the extent it did, they were pretty quickly disposed of in Reno v. ACLU. Here, I think they are more complex. Nonetheless, I think that the AI output is protected by the First Amendment, although subject to some of the First Amendment exceptions. So that's my kind of quick bottom line. I'm happy to explain why and when, but I don't want to.
No, and I want to, okay. My first set of questions are, for those who haven't yet read these pieces, and I commend them to you, and they're actually both, very, very easily digestible pieces in wonderful, deep ways. So I'm going to ask you some questions about that, but let me just continue the parlor game, right? I mean, implicit in my bringing up this article of Eugene's is how much should we be looking at AI as a moment that is as big as the dawn of the commercial internet, right? I mean, in terms of all of the disruptions we've been talking about generally, but in terms of your paper on the challenges to the regulatory state, is this on par with? And Chini, you might have been too young to remember this, but is this on par with the web browser, or is this nothing like that, or is it much more hair on fire than that moment was?
So I think Chini actually had a version of this conversation last night in the hotel bar, where I was sort of waxing on insufferably about how magical AI was and how I got into this field because 2 years ago I spent 20 minutes talking to ChatGPT-3, which in retrospect is a remarkably stupid model. And for the next week, I was just walking around in a daze going, whoa, this is amazing. I'm going to spend the rest of my life doing this. And I think Chini's response was, yeah, I wasn't that impressed. At which point I accused Chini of being dead inside, and she, right, so it was the whole thing.
I accused him of being dumb.
Yeah, exactly. It was great. It was the usual Chini in my conversation. Yeah. So my answer is I think this is every bit as important, quite possibly more so. I think it's also, for exactly the reasons Eugene articulated, I think much, much harder, right? Most internet First Amendment cases, they're incredibly important, but they're actually not that complicated, right? Because it's just speech. And the fact that it's speech, going through the tubes, the internet is a series of tubes, right? Doesn't really change the fact that it's speech, right? Any more than the fact that speech is over a telegraph or a radio changes that it's speech. Whereas AI is different, right? AI, because it is generative, raises a lot of sort of interesting questions, and I hope we get to, right, questions, not just, is it covered, but how is it covered? So I do think it is a massive deal. Chini, what about you?
I just like to disagree with Alan. So obviously, last night I was like, "You're dumb," and that was not the right response. But I do genuinely agree that this is like it's rare that I think new technology actually raises novel questions, and I do feel like the fact that AI generates content that is not perfectly predictable to the developers that built it is a very interesting phenomenon. I get frustrated when people call 2021 or 2022 is an inflection point and now everything's changed in the world, because this has been happening behind the scenes and been developed for years and years and years and years. This isn't like magical new technology that just hit the scene. Neural nets were used in commercial sectors before LLMs came out. Generative AI is not all AI. So I have my shtick about that. And I do think that this distracts from larger AI problems to focus only on the commercial and user-based products that are out today. That being said, I think that when I talk to people that are like, AI is going to change the world, I'm yes, and so have a lot of other things. I do think it is important to start talking about AGI, whether it is 5, 10, 50, or 75 years down the road, or maybe totally impossible. I still think it's worth having the conversation. But when I talk to people that are like, AI is no different than any other technology that has hit the scene, I'm like, that also feels wrong. And so I think that this is a long-winded way of saying it's the very predictable answer of, I think it's more complicated and it's like a both-and situation.
Let me do a quick aside to elaborate on something Alan did when he was moderating. I helped found a center called the Silicon Flatiron Center at the University of Colorado. It was run by a gentleman named Phil Weiser, who's now the Attorney General of Colorado. Sorry, I just dropped a name. But one thing Phil Weiser did, and I lovingly call it the Weiser rule, is he had this rule that the first question of every panel of every conference had to be asked by a student. And I've learned that the students always ask the best questions, and I've also learned that it causes all of you to have a lot of stress and anxiety during the panel, which I think is a plus. But I'm a law professor, so if one of you doesn't volunteer to be the first in line, I know how to call on you. Okay, so let's dip into, I don't want to replay all of your posts, but Eugene, one of the early kind of moves you make in the paper is you say, and this I think is well established in the doctrine, the First Amendment is about listeners, not just about speakers. And so maybe we can almost do away with the kind of, frankly, philosophical question of is this thing speaking? Is it thinking? Are the programmers? You're saying almost that may not matter in the end.
Right. Or may not matter that much. So let's just get concrete. Imagine that the government were to say, it could be federal government, state government, could be Trump administration, could be Harris administration, whatever. The government says, we don't like the fact that AI programs are outputting certain kinds of answers to certain kinds of prompts, certain kinds of responses. So we're going to make it illegal for the AI companies to allow that. Now, an interesting question, to what extent will they have some defense saying, we really tried really hard, but somebody jailbreaked, is it jailbreaked or jailbroke? I don't know. The software. Bracket that, because you can have defenses of a reasonable mistake or some such. But look, we don't want them outputting racist material, or we don't want them outputting anti-police material, or we don't want them outputting pro-Hamas material, let's say. Can the government do that? Now, of course, one possible response is the First Amendment, and it says, look, we're perfectly fine with human beings outputting things. We're even fine with corporations outputting things, because corporations are ultimately human beings, and if somebody wants to write something for the corporation that then the corporate managers endorses the voice of the corporation, that's protected. But this is just software generating it, and that's not protected. I'm inclined to say that would be unconstitutional. Why? So one possible answer is there is a right of the speaker involved. The speaker is the company. The company creates the software that outputs it. The company trains the software, sometimes just trains it on on the underlying corpus, which it may not even anticipate what the output will be like, but often it custom trains it through reinforcement learning through human feedback or whatever else you've got. You know, they may say, yeah, it outputs certain kinds of viewpoints because those are the viewpoints we want them to output. So that's one possibility. But I think even independently of that, there are listener rights. And let me just give you one specific case. It turns out it's the first case, a trivia question, speaking of building in the previous panel. When was the first time the Supreme Court struck down a federal statute on First Amendment grounds? Turns out it happened in 1965, pretty late. And the case is Lamont v. Postmaster General, and it involved a law that said if you want to get mailings from foreign countries, generally from foreign governments, of communist propaganda, you can get them. You just need to go to the post office and say, I want to be I am willing to get this material. And the court struck it down, not on the grounds that foreigners from overseas, especially foreign governments, have First Amendment rights. Maybe they do, but it's far from clear that they do. But on the grounds that the recipients have rights to receive them without having to go get on a list of people who like communist propaganda, right? So I think the rationale would apply here as well in two ways, at least two ways. One is somebody may say, you know, I want to read this racist argument, or I want to read this pro-Hamas argument. And this is a good way of getting this argument, and therefore this is something that I should be able to access, and you can't block me from it, you the government, in a viewpoint-based way, or content-based, or whatever the First Amendment rules are. But another possibility is listeners as speakers, right? One of the reasons people use LLMs is to get information that they could then, or get text that they could then edit some and then repost further. So a person may say, I'm not just a listener, I'm a speaker. I asked it to compose a Facebook post that would make this argument, and I'm entitled to get that free from government interference. So that's why I think there would be First Amendment protection. Note, such protection is not absolute, just like protection for human speech is not absolute. So returning to the first panel, libel, for example, if a company outputs libelous material, you know, that's not protected by the First Amendment when humans do it. It's hard to see why it would be protected when AIs do it. Likewise, there are interesting questions. What happens if it outputs information that is false but physically harmful? It tells you some mushroom is safe to eat and it turns out it's poisonous. Or then the variety of other kinds of such questions. Those would have to be filtered through First Amendment law. But my point is there is a First Amendment protection. It's not just like the government can with regard to non-speech products say we're going to regulate them just because we think it's in the national interest or anything.
Yeah, so I want to almost entirely agree with what Eugene said before I disagree slightly.
Where's the fun in that?
Yeah, no, I'll get to it. I want to mostly agree with what Eugene said, and I want to go maybe even further and say I suspect that this listener theory, whether listeners as listeners or listeners as speakers, is going to very quickly become the sort of conventional wisdom among both academics and especially judges when this gets to the courts, precisely because it allows everyone to sidestep the very much more complicated, both technically and sort of conceptually, in both technical and conceptual sense, the question of, are these AI models thinking? Are they speaking? To what extent are they, is ChatGPT speaking for OpenAI or Sam Altman? That's too hard, right? Whereas the listener answer is very straightforward, right? It's pretty obvious, right? And I think it's definitely true. And yet, the thing that I think still makes it more complicated than just saying that is because the doctrine does distinguish the level of First Amendment protection sometimes of what kind of speech the listener has access to. And here's what I mean. So it's one thing to say, and here I do agree here with Eugene, that this stuff is definitely First Amendment protected in the sense that the First Amendment applies here, right? This is not a case where the First Amendment just doesn't apply and therefore you can do anything. Yet there are cases that distinguish, for example, between listeners having access to speech itself versus listeners having access to a tool that they then use for speech purposes, right? So one can imagine, for example, that the law might treat a restriction on, for example, text that a listener can get differently than it might restrict, access that a listener might have to, let's say, a typewriter, right? A tool for speech. And so I do wonder. This is good. This is a face that means there will be a response. This is good. Getting Eugene to scrunch his face is like one of my main goals in life. Right. So just saying the First Amendment is implicated here, right, might a court still say it's implicated, but really this is a tool for speech, not necessarily speech itself, and therefore we might allow, under intermediate scrutiny. Maybe the appropriate thing is intermediate scrutiny. Yeah, no, clearly I'm wrong here.
Well, so as a general matter, speaking often requires a wide range of tools. One tool is the printing press and its technological heirs, right? The internet is a tool. A bullhorn may be a tool, right? A camera is a tool for creating a particular kind of speech, as well as a tool for kind of viewers to capture something just for their own purposes. But there are other things which aren't physical tools, like it requires other things, like if you're going to have a demonstration, you have to be physically there and you might block roads or entrances or whatever else. The law, I don't think, treats tool-assisted speech really that differently from things that are not conventionally seen as tool-assisted. Rather, what it distinguishes as a general matter is between restrictions that are justified by the non-content features of the tool or of the speech, and those that are justified by the content. So, for example, the bullhorn is a very powerful tool for speaking, but the government can say, we will restrict you from using the bullhorn in certain places at certain times, outside a hospital, let's say, or at night in a residential area. But that's not because it's restricting a tool, because it can also restrict things we don't think of as tools. Like we could say we can restrict you from demonstrating on the street, at least unless you have a parade permit. It's not that your demonstration is a tool, it's that it's a content-neutral restriction that passes the more relaxed standard available there, I think. So as a result, it's true if the government were to say, we're going to put a tax on AI, large language models, because they consume so much electricity that they create externalities that we need this tax in order to deal with. It's an interesting question whether it could be unjustifiable. In any case, there's special rules having to do with taxes on the press, but at least you could say, okay, that's a content-neutral rationale. But I had to really work hard to get this one because there are very few content-neutral rationales for regulating LLMs, right? As a general matter, if the government wants to regulate an LLM, it's because it doesn't like the output that the LLM will produce. So the fact that it's a tool, it seems to me, would no more justify those content-based regulations than, or even lower the level of scrutiny than if the government were to say, if you want to buy a typewriter and use it to convey these messages, we're going to put a tax on it or otherwise restrict it. That's my thinking.
So is it fair to say safety audits or mandatory reporting requirements would be seen as content neutral?
So
on LLMs?
So I think I know what you mean by safety audits, but before responding, I want to make sure I do.
A couple of the bills right now, the EU AI, are like mirroring the EU AIX call for or mandate on companies of a certain size to have safety audits.
Okay, but safety, I take it, doesn't mean, I start typing it, I get a shock because it broke the keyboard, right? That's not the safety we're talking about. The safety is stems from a concern about the content, right? Almost invariably, when people talk about LLM safety, it's a worry that the LLM will output material that is harmful. To some people, it's because it conveys harmful viewpoints. To some people, it's that it's harmful because it's false. It could be that it's harmful because it tells me to eat the wrong mushroom. That is actually a physical harm, but it is a harm that flows from the content of the output. Am I right that the safety audits would all be having to do with that?
Not always.
Well, give me an example of a safety audit that aims at a harm that is unrelated to the content of the output of the LLM.
Could be endless scroll. Right? It's just like we don't want people to be addicted, and so we want mandatory, we think it's best practice to give people a break every 20 minutes.
So,
right?
That's an interesting point. Yeah. I appreciate it. It's a question that's coming up right now with the social media platforms. That's where people are most concerned about. It's not clear to me that that is a content-neutral rationale. It's true it doesn't single out some particular subject matter, but the concern is that the content is so appealing to people that they're spending too much time on it. But yeah, in principle, you could, at the very least, that's a plausible case for content neutrality. I haven't heard of any safety audits that are aimed at that we're just afraid that people will fall in love with their LLMs and then stop having human relationships, stop eating, right? Maybe that's the concern,
I mean,
but I don't think that's
OpenAI
what safety audits today are about.
I think it's not mostly what they're about. You're right. It's mostly about, oh my God, this LLM, when you ask it how to make a nuclear reactor, a nuclear bomb in your basement, it gives you, here's 3 easy steps. But I actually do think, this question of design, right, which is coming up in the platform. Yeah, you're right. Coming up in these platform cases, it's also going to come up in AI really soon. I mean, just literally this week, OpenAI released its advanced voice model, which was, if you may recall, this 6 months ago, they announced this really remarkable voice model you could really talk to. It sounds suspiciously like Scarlett Johansson from the movie Her.
Not anymore.
Not anymore. But the vibe is very similar. And it pushed it all out to ChatGPT. If you have the plus, if you pay the $20 a month. So on my phone right now, right, I can pull this up. And there's an interesting question, will people get addicted to this? I think some will, and you can imagine this being an issue. And then the question is, is the nature in which the content is presented, is that itself content-based or content neutral?
Right. So it's an interesting question. Those are the right questions to ask under First Amendment law, right? So once you say something is subject to First Amendment protection, then pretty much the first question ends up being, are you trying to restrict it because of content, or to be precise, things that flow from the communicative impact, that it conveys certain information or conveys certain ideas or the like, or for things that are unrelated, like it causes eye strain, or it causes people to lose sleep, not because they're upset at what they read, but lose sleep because they spend too much time on it, let's say. So then, if you conclude that it's content neutral, then generally the government has fairly broad latitude to restrict that, so long as it leaves open ample alternative channels for communication. On the other hand, if it's content-based, then as a general matter, it can't be restricted unless it fits within one of the existing exceptions, like for libel or building a nuclear bomb. I mean, if the first step is find some uranium in your basement, maybe it turns out it's not that harmful. But there actually is pre-internet or case law, certainly pre-AI case law, very little of it, but still about whether or not that can be restricted. But the theory would be there's some exception for speech that is so harmful because it allows the creation of weapons of mass destruction, let's say. But that would be the analysis you'd have to go through.
So let's stick with the First Amendment, since I didn't want to box out the other people on the panel, and you clearly are not feeling boxed out. So
exactly.
So
Shinny and I will not be boxed out.
So
that's not how we roll.
Not your style, yeah. So there was another argument you made in your piece, Eugene, where you were responding to a provocative argument. So the argument you were responding to was large language models are just picking tiles out of a Scrabble bag.
Right.
Right? And so the idea that anyone could be, I think this was in the context of defamation.
Yeah.
The idea that anyone could be defamed, I don't know, I'm just playing out this argument I didn't see, is ridiculous because no one's going to believe that these are assertions of fact when they're just tiles picked.
Right.
I don't know if I'm characterizing that argument right, but then what's your response?
Well, that is certainly an argument I've heard. There were variants of it. Ouija board, monkeys at typewriters, you can, a Magic 8 Ball. And my answer was I don't think the Magic 8 Ball Corporation was getting billions of dollars from people who were planning to commercialize Magic 8 Balls.
There is a TikTok trend about Magic 8 Balls, so maybe they're getting...
Oh, fair enough. They're getting something. It's true that if people just sort of see something as a toy, as a game, and it happens to output something that says Volokh has been convicted of killing dogs, then in that case, they would probably laugh and say, funny that it should output this, but wouldn't take it at all seriously. But if you've got, say, a search engine which has enough confidence in the quality of the output, not perfect confidence, but enough that it outputs things like at the top of a search, by default gives this, then unsurprisingly, I think, most readers would assume that this is not perfect, but fair, but reliable enough that it's way beyond the picking tiles out of the Scrabble bag scenario. And once that's so, it turns out libel law is familiar with situations where people rely on things that are not completely reliable. The classic example is rumor, right? That everybody knows rumors aren't always true, but they also know that rumors aren't completely random. So they're sometimes true, and people believe them. And if I spread a rumor, even if I preface it saying, rumor has it that Joe Schmo has been convicted of killing dogs, then in that case I could be liable, even if we might say in a perfect world, listeners would say, I'm not going to pay any attention to that, that's just a rumor. In the real world, people do pay attention to such things, and thus liability follows reality.
This is the form of a question I could have just Googled it, but this is more efficient. I mean, Eugene, among other things, you track these defamation cases closer than anyone.
Yes.
I learn about all of them when you post to CyberProf, our listserv. So what's the most advanced one of these cases gotten?
Right.
Have there been motions about the First Amendment question yet?
Yes, so there are two.
Yeah.
One is in Federal District Court in Maryland. The plaintiff is pro se. This is a great opportunity for someone to take this up, represent him. You may win or lose, but this is really cutting edge.
Yeah.
So it's Jeffrey Battle. He spells it Jeffery. And he says when you, it turns out to be important.
I was going to say.
We'll get to that. Play along with me here. So Jeffery Battle says, I went to Bing and I entered my name, and I get the following. It says, Jeffery Battle is a retired Air Force officer who now has a business under the name of the aerospace professor doing consulting in aerospace. He used to teach at Embry-Riddle University. So far, it's quite accurate. However, Battle was also convicted of levying war in the United States and sentenced to 18 years in federal prison. Whether the part about Battle being convicted, Jeffrey, not Jeffery, is also true. The falsity comes in the two words, however, comma, Battle. There are two people named Battle. As it happens, they have different first names, although it's very similar, although similar questions would arise if they had the same name. And the problem is that Bing merged the two together, and the however, comma, Battle is a signal to readers, those two are the same thing. If this had been a newspaper that did it, it would be a very solid libel case, right? They could say, we didn't intend to do this, although he also says he let Microsoft know about this. And they said, we're going to try to fix it, and they didn't, at least for a month. They didn't. So that might be knowledge or recklessness as to falsehood. That's one case, and right now it's hasn't gone anywhere beyond the original pleadings, even though it's been pending for a long time, in part because he's pro se. The other case is Walters v. OpenAI. Mark Walters is he's a commentator, a gun rights commentator. And apparently somebody else, who as it happens knew him, but I don't think there was any collusion at the outset, asked ChatGPT 3.5, what happened in this complaint, which is a complaint Second Amendment Foundation, I want to say, versus Ferguson, the Attorney General of Washington. And out comes, this is a lawsuit against Mark Walters for embezzling from the Second Amendment Foundation. It's not a lawsuit against Mark Walters. Walters is not even mentioned in the lawsuit. It's not about embezzlement. It's a facial challenge to Washington gun control law. Somehow it creates this. It gets filed in Georgia Superior Court. By the way, when your law professor, your CivPro professor said this is the most important class you're going to take in law school, that person was right. What happens is OpenAI removes it to federal court, which is for the usual reasons that are often given, probably the right move for them. It's sort of cutting edge legal theory, probably more likely to be better handled by a federal judge. And then it gets remanded back because OpenAI is not a corporation, it is an LLC. And for diversity purposes, the citizenship of an LLC is the citizenship of all of its members. And if the members are LLCs, then it's their members, and then it turtles all the way down. Wow. So it ended up being remanded back to Georgia Superior Court. They file a motion to dismiss on various grounds, including, I believe, First Amendment grounds, and the judge, in a one-line order, which is quite common in state court, although not as much in federal court, denies the motion. So the case is still progressing in Georgia Superior Court in Gwinnett County. Those are the two cases that I know of in the US.
Any follow-ups on libel? I'm going to move past libel. Okay.
I just can't, how could you bring civil procedure into this? Eugene? How could you bring civil procedure? This is a safe space. And
So
here I
this
have to
is
think about diversity jurisdiction for Al. How
exactly.
could you?
The lawyer's true superpower is we have the power to turn every question into a question about procedure.
That's true. Okay, so question about the regulatory state. And I actually have a few questions at the end that are gonna combine the two papers. Just, I like setting myself up with high expectations that I cannot meet. For those who have not thought much about the regulatory state and how it applies to technology companies generally, not just AI, this is such a useful primer. I mean, you cover so much waterfront so efficiently. And then you do this pro and con list about whether we want agencies, whether we think they're the right regulators for this moment. And so your pros are expertise, speed, agility, scope, and democratic responsiveness, and your cons are lack of resources, political challenges, legal constraints, and overreach. And like so many of the final exams in my class, you don't weigh the pros against the cons. You just leave this hanging. And so at the risk of like overgeneralizing, like you could pick one agency or one context if you want, as you do at the end of your paper. Worth it? Worth the candle? Are these pros pro enough that they outweigh some of these constraints?
So,
like, are you bullish about the regulatory
I'll give my
state
answer,
in
and I
this
feel
space?
like Alan and I are going to differ on this,
Yeah.
which just goes to show, like,
brand.
it's on brand. But I would say it is worth it. I do think that, and it's kind of similar to what a lot of the panelists on the first panel said, I think that right now there is a need to move in this space, and I think that my concern that agency rules will be wrong and then we won't be able to retract them are not as high as my concerns that the EUI Act is going to end up being an act that created a loophole that's bigger than the mandates. But I also think it is it matters which agency it is. Some agencies are better than other agencies at investigations and enforcements. It also matters because I think some agencies have the judiciary is more antagonistic to some agencies than other agencies. I think that some agencies and other agencies, some agencies more than other agencies have like better political capital with Congress, and so are more likely to get the resources they need to do things. But all of that aside, I think that I would like more regulation, but to undercut my own position, it's an empirical question that I don't think anyone on this panel has the answers to, which is like, is agency enforcement actually effective in influencing change across an industry as opposed to specific enforcement against one company? And then even in terms of specific enforcement against one company, is agency action actually able to get long-lasting change, or is it kind of a one moment in time penalty or casting light on an issue that passes and it's like business as usual?
Yeah, so, no, that's great. So a couple of thoughts. So I'm gonna stick up for a second for the not doing the weighing of the pros and cons. I mean, the real reason is because
this is the classic, I reject the premise.
I reject the premise. I mean, the real answer is because it's too hard. But the more principled answer that I just made up on the spot is that I think that it is important to be very tentative to the point of sometimes just staying silent on these bottom line normative evaluative questions. Because it underscores how early we are in what, again, going back to sort of your first question, I think it was a really transformative technology. I mean, if you were to ask at the beginning of the Industrial Revolution, what should the role of the law be, right? I think the most honest answer would be, here are 17 considerations, I'll get back to you, right? But I'm just not in a position to tell you, and as the steam engine is suddenly developed, what the role of the law should be, right? And even if you don't think that AI is like the steam engine, hopefully I can convince everyone, even some of the skeptics, that it's something, at least it's like the railroad, right? Which is to say, maybe not an earth-shattering technology, but like a really big deal technology already, right? Even if we don't make any more advances, right? Which we will, if you just look at the scaling law graphs, even if AI stopped today, right? Just the effect of that ramifying through the industry and society and the economy over the next 10 years would be massive, right? And I think, again, if you were to ask, what should the law do with railroads in 1860, you have to be like, I don't know, we'll have to wait and see. And part of it is this empirical question. You got to go agency by agency, sort of specific thing by thing.
But also technology by technology. Like you brought up steam
absolutely.
railroad, but we've also brought up the analogies of cars. Like I think that David made this point earlier, like regulation of cars has not quelled the thirst for cars in America. I think that it depends on the technology and how high the demand for the technology is and how inclined suppliers are to kind of overcome regulation to be like, no, I think we could regulate the crap out of AI and OpenAI is still likely to continue producing AI and we're likely to continue consuming AI.
Yeah, I think that's right. And that gets to the second point, which is, to say, yes, regulation is worth it or not worth it, it depends on what you're comparing it to, right? So I actually totally agree with Chinny that compared to courts and the common law, I think that regulation at the very least should be as important, right? I'm not going to say it's more important, right? I mean, courts have a lot of wisdom, common law has a lot of wisdom. I'm not such a technocrat that I think that everything should be done from the Department of AI here in DC. But for these reasons of scope, speed, potential for technical expertise, I think you have to get the agencies involved. Where maybe I disagree with Chinny, right? And this is like one of the many reasons it's so much fun to work together on this sort of stuff is, without putting words into your mouth, Chinny, I think it is a fair statement to say that you are generally a little more concerned about harms of AI, and I am a little more concerned, right, about the potential benefits and the risks to innovation, right? We're both
I do think innovation's overrated.
Yeah, I think we're both concerned about both things, but sort of, you're more of the safety person, I'm more of the AI accelerationist. So where I think you and I may disagree is I am concerned about premature regulation. I'm concerned about it whether or not it's from the courts. I'm concerned about it whether or not it's from the agencies, right? I do think, I think you got to let them cook a little bit.
I don't actually disagree with that.
Well, there was the fun
I
of that.
do like the laboratories of experiment
Wait,
kind of
I'll
concept.
disagree with that. So let's talk about the automobile.
Yeah.
Right? So we let that cook for a couple of decades. Lots of people were killed.
Yeah.
Alan's like, no problem.
You're like, I mean, none of your direct
I would
ancestors, so maybe no.
But I am against automobile
But
death.
not only that,
Thank you coming from my tech talk.
Not only that, but maybe similar to what we're doing with AI, the federal government decided to intervene to make certain things easier for car manufacturers. And so we ended up with the interstate highway system, which begot the suburbs, right? I mean, there is an argument that we waited too long with cars and that we kind of screwed up some things fundamentally that if we had, with all appropriate humility, intervened a little bit earlier or didn't do things quite the way we did, we'd have a better world in some ways.
Yeah, no, I think so. I think there are two questions there, right? So the first is the counterfactual question of take some technology like cars. Did we in fact wait too long, right? Should it have taken Ralph Nader pointing to Ford Pintos blowing up for us to get our act together, right? And that's an interesting question, and there are all these counterfactuals, and you have to ask, okay, well, how much life was improved by having cars for somebody? I don't know the answer to that question. But fair point. But the second counterfactual is what is the right comparator? Because you can say, right, okay, fine, we waited too long on cars, but maybe I might respond and say, sure, but cars is the wrong example. Nuclear power is the right example, right? We over-rotated way too much on restricting nuclear power. We overlearned the lesson of Chernobyl, right? We certainly overlearned the lesson of 3 Mile Island, right? Which, by the way, is back because of AI. Fun coincidence, right? And in fact, we've contributed just by our, insane aversion to nuclear, a full, 0.3 degrees of global warming just based on that, which is a big deal, and God knows how many deaths because instead of nuclear, we burned a bunch of coal and put that crap into the air, right? So if that's the right comparator, right, and I think there are reasons to think that AI could be the sort of, science and welfare advancing technology that nuclear power could have been, right, that's the issue. So again, I think all we can do, and maybe this is kind of a meta point, is we should just identify what our priors are, and maybe my priors are a little more techno-optimist, and maybe your priors are a little more techno-pessimist or techno-realist, however you want to call it. But then just hold those priors very lightly and be good Bayesian updaters and just be willing every day to sort of relook and say, today I'm feeling better about it, today I'm feeling worse about it. But just not to commit too much, right, off the top. Now that's easy for an academic to say, right? It's harder for, I don't know if David is still here, but it's harder for a government official or a judge who has to make a decision, and we're not deciding is itself a decision not to decide. But it's why I like being an academic.
I think that's the feature of regulatory law is that you can make the decision with at least less consequence long-term than some of the other modes of regulation that we have. I actually think that tort is also good at this because you can have one case in one jurisdiction and a different case in a different jurisdiction, and they can have similar facts and come out differently, and you can see how we like the results of that. But again, this is kind of like to my earlier point about not all AI is generative AI. Like the car analogy and the nuclear energy analogy might be apt for different kinds of technologies, different kinds of use cases. And then another feature of the regulatory world is that we have a lot of different agencies that even if we don't, I'm skeptical about like a big AI law, even if we don't get to holistic AI regulation for all AI, we have agencies that address a lot of high-risk industries that might be already pretty technically competent at figuring out what kind of AI is nuclear and what kind of AI is cars within their domain. And I think that I'm never going to remember the acronym, the National Highway and Transportation Services, NHTSA. I need to do better at remembering the pronunciation of the acronyms, as if they're words, is trying to do a good job of pulling together stakeholders and technologists to understand what's going on with autonomous vehicles and different kinds of autonomous vehicles. And telecom is brought in because autonomous vehicles need to communicate over spectrum. And so what kind of spectrum bands do they need to use? So it's not just an AI question, and it's not just a car question. It's a multidisciplinary question.
Sorry, no,
Yeah,
we're just setting the cue here.
No,
You good?
I'll stop. I hate being
Eugene didn't
verbose.
scrunch his face, but you look like you have
So,
something to say.
I just want to add an extra thing to the mix, which I'm sure you folks have thought about, but it hasn't really appeared as to the administrative agency question. What about the state versus federal question, right? Yeah. When we're talking about tort law, of course, that's all state with some variation among states, and yet it can apply to national and transnational companies. Cars, historically, they've been regulated at the state level as well as at the federal level in some measure. And what's more, there are particular political difficulties in Washington, D.C. with creating a new agency or creating a new statute or whatever. But we've got 50 states, some of which are deep red, some of which are deep blue, and if they decide they want to create a new agency, they can do it pretty quickly. And there may be not the same kind of ad law constraints at the state level as there are at the federal level. Different states have very different approaches to the restraints on agencies. So what do you think about the state?
Did Gavin Newsom sign the bill yet? Do we know? Not
No.
yet? Not yet. He has what, 2 more days, 3 more days?
Yeah.
I think
Anyway,
till Monday.
Yeah, and I hear whispers that maybe he'll obviously veto the thing, which is what I thought. Maybe that's not. Maybe that won't happen. We'll see. So I thought about this some. So on the one hand, I think it is I actually do think laboratories of democracy is a very cool thing, and I think we actually
not laboratories of experiments.
Well, and I think it is a good thing, and absolutely states should be experimenting with all sorts of things, right? And they are, right? But I think they have to be extremely careful about regulating about stuff in which they have a specific and can articulate their specific state interest, rather than regulating about things that are both not particularly in their state interest and especially in ways that might affect AI across the country.
Wait, are you making a policy argument or a con law argument?
So I'm making primarily a policy argument, but maybe there's a con law argument here. So the policy argument, and I think Dean Ball was in the audience, but I think he had to leave. So he and I wrote a piece for Lawfare a few months ago saying when SB 1047 was about to be enacted, or not about to be passed through the California legislature, that Congress should seriously consider federal law preempting state safety legislation, right? Because the sort of legislation that I think SB 1047 is trying to get at is trying to prevent, not like specific harms to individual Californians, but trying to prevent AI being able to create nuclear weapons, let's say, right? And in our view, that is not primarily a California-based concern. That is a concern for the nation as a whole. And the problem with something like California doing that is because the spillover effects, because the AI labs happen to be located largely in California, would be spillover effects nationally. And if you're concerned about innovation and geopolitical competition, that's the sort of thing that should be decided at the national level. Now, this is without prejudice to the substantive question of what should the AI safety standards be, and is sacrificing some innovation worth a marginal decrease in the risk of AI causing nuclear war, right? Like, that's a totally separate conversation. Now, that's a policy argument. There's a constitutional version of that policy argument, which is that the doctrine known as the Dormant Commerce Clause says that at a certain point, state regulations, even for otherwise legitimate non-protectionist purposes of interstate, of out-of-state commerce, right, or even potentially maybe intrastate commerce, can be struck down even in the absence of federal legislation that preempts that, because of the particularly bad effect on interstate commerce. Now, the health of that doctrine is extremely contested. There was this case from a few years ago about California. It's usually California cases in Dormant Commerce Clause. I'm not trying to pick on California, because California is
I think California wants to be picked on.
Well, it definitely does. But it's just because California is such a massive economy. It's like the 5th biggest economy in the world. Anything California does has a California effect. And there was this case about California regulating pork production, and it went to the Supreme Court, and I've read that case 4 times. I'm still not sure what the case actually says. But I would argue, either on policy or constitutional grounds, for there to be some limits, actually, on, in particular, California, because that's where it's going to matter the most. Now, the only thing I would say is, I've lost my train of thought. I don't know what I would say.
Sorry, I just so obviously was about to interrupt you. I think that
do
that
it.
threw you off.
Go, jump in.
But no, I'm asking a purely rhetorical question, not a leading question.
Yeah.
But is there not, taking my lawyer hat off and just being like a practical or political person, is there not value to California using its might in the I regulate all tech companies and that's going to regulate across the country to say we're going to do this and this is going to put pressure on the national level to address this question to preempt, because now it's the stakes have been raised?
Yeah, no, there's an interesting second order question here, right, of state as forcing Congress to act, and maybe
it's net neutrality. It's worked.
Yeah. No,
medium well.
Yeah, you may be right. I mean, there may be sort of Congress is so deadlocked that as a second best answer to Congress getting its act together, you need states to screw things up potentially so Congress can act, and that may be the answer to the Dormant Commerce Clause argument, and honestly why many people don't like the Dormant Commerce Clause is because Congress could always act to just do this under its regular Commerce Clause powers. But I think there's still the policy question of, I still think it would be better that these kinds of issues were decided at the national level. The thing I wanted to say was, there are counter arguments here, right? People often point to California's role in increasing auto emission standards, and the California effect, because if you're a car company, you're not going to make a California, a really environmentally effective California car and then have some less effective car for the rest of the country because of scale. But the problem with that analogy I've always found is it kind of begs the question that California is setting good, all things considered, auto emission standards relative to the increase in cost that it does. Now, I think in the car example, there's a good argument to me that it does, but I think the problem is that this question of AI safety legislation is extremely contentious, and the whole question is, what is the right balance? And so that's my overlong take on the state-federal thing.
Yeah, it's so funny. I'm looking at my 17 questions, trying to pick the one more question I want to ask, because I do want to get to your questions in about 7 minutes. And remember, a student has to go first. I mean, this is going to feel like a real point of personal privilege question, but the one topic we haven't talked much about today is privacy, and I'm a privacy scholar. And I actually think I can combine your 2 papers in a sense. Let's see if I can pull this off, which is, it might have been Eugene. Someone today talked a lot about the idea that it was during David Lawrence's talk, that ad personalization is very likely to be coming soon to a large language model near you, right? I can't imagine how annoying that's going to be. Like, yeah, I'll tell the story to your son, but first, let me tell you about this juice box you should be buying. And it feels like...
But I'm sorry, will the annoying thing be the ads or that they're personalized?
Probably both.
Because maybe the ads, if they know me well enough, they'll actually give me an ad that I like.
I
There's
find
no
that
such
very
thing.
annoying, though, because then I spend money
There's
on
no
dumb
such thing.
stuff.
Anyone who ever
Well-
says, I like personalized ads, has been fooled by the ad industry to say something they don't really believe because they don't ever click on them. I love unpersonalized ads where they think I'm a 35-year-old pregnant woman. That is my happiest day because I've beaten the machine. And then Leo Horst-Strilovich, when I said this once, said, yeah, but Paul, they've realized you love that, and so that's why they're...
And also, Paul, it's because you too deserve the foot massage, the water foot massage device.
No, but so my question about the regulatory state is, first of all, the FTC seems like the home for worrying about this. But does this even rank? I mean, today, Ellen's been talking about death, destruction, nuclear power. Like, is privacy something that we should even factor in these conversations? And then for you, Gene, I want to hear more about commercial speech doctrine and whether or not it's likely that some of these, pro-privacy regulations might work because a court, it's hard to imagine, the Supreme Court would say intermediate scrutiny or something like this. So I don't know which of those you want to take first.
Okay, so I'll do a quick thing on the privacy thing. So I think that there's a two-part if I think about it. So the first question is the substantive question of how important is privacy versus other things, right? My gimmick is that I'm like the anti-privacy law professor because it's just fun to go to privacy conferences and see what happens. But I think we could just have a range of views of what is the actual privacy interest, what is the harm of the privacy intrusion, what is the benefit you might get to it, right? On net, on the one hand, you might think it's really bad that all these AIs will know everything about you. That's a horrible privacy intrusion. On the other hand, it's kind of amazing that you can ask very sensitive questions to an AI rather than have to go talk to maybe a human being. So maybe on net is privacy improving. So there's a whole kind of substantive set of questions there. But then there's this institutional question of who should decide. And I actually think that getting to this question of how should regulatory agencies think about AI interventions? I think I kind of like the FTC doing privacy stuff because it's somewhat narrow and somewhat tractable. I mean, it itself is very complicated, but the thing I think the sort of the kind of guiding the North Star of the institutional design question should be you should have specialized agencies narrowly focusing on stuff that they have expertise in, right? Like the scariest thing I could imagine is a department of artificial intelligence. Like that's, I think, the last thing that anyone would want because they're not gonna be very effective. It's gonna be very abstract. It's not gonna work. Whereas if the FTC has been doing privacy law, right? And they've been doing privacy law, for 30 years in certain domains, and now ChatGPT presents that question in a slightly new technical context, right? I am much more comfortable with the FTC taking a bite at that apple, right? Than at the FTC doing AI law generally. That's what I will say about that.
So I think there are two questions here. One just about commercial speech generally. Commercial speech, usually, I oversimplify here, is shorthand for commercial advertising. And it's pretty well settled that misleading commercial advertising is constitutionally unprotected. It's not enough just to say, oh, we think it's misleading. There's got to be some real evidence, but if there is sufficient evidence, it's unprotected. And non-misleading commercial advertising is subject to less protection, although it's ebbed and flowed. Starting with the late 70s, in the late 70s, it looked like it would get a lot. Then in the 80s, there were a bunch of cases that said, no, it actually would get quite modest protection. And ever since then, there's been quite a bit of protection. Not absolute protection, of course, but also not as much as for non-commercial speech that's not commercial advertising, but considerable. So if, let's say, OpenAI starts serving up ads and they're misleading, whether because it bought misleading ads or it hallucinated things into those ads, that would be regulable. If, however, let's say it is producing ads that are not misleading, but personalized, and somebody says, well, that's bad, it's bad to have personalized ads, I think courts would look at it quite skeptically and say these are constitutionally protected in some measure. It's not enough just to say they're icky or they're bad or they might get you maybe too effective at getting you things to buy. That just means they're persuasive. So it may be very difficult to do that. But let me turn to the privacy issue and step back and try to merge it a little bit with the liability stuff we talked about earlier. So there's this phenomenon I talked about 10 years ago, way outside of AI, of tort law versus privacy. Tort law is sometimes seen as a protector for privacy, because there are various privacy torts that are aimed at protecting that. But the law of negligence and related liability doctrines is also potentially a threat to privacy. Just to give one example, in a lot of cases now, if somebody is injured or criminally attacked on someone's property, say in a parking lot of a mall, it's now a routine claim they were negligent in not putting up cameras. Because as the technology got cheaper and more effective, the claim was that you should take reasonable measures to protect us, by using cameras, became much more plausible. And the objection that, well, wait a minute, maybe we shouldn't have more surveillance, that's a hard objection. It could be factored into the analysis, but often isn't. So let me give you the following hypothetical fact pattern. Somebody uses an AI program to ask something like, what substances are poisonous but not easily detectable in an autopsy? Now, there are a couple of possible reasons for that. One is you want to commit murder. Another is you're a novelist. And in fact, there are novels you can read that presumably talk about it. Another is you're just curious. Another is you're training to be a medical examiner, and you're looking, or a police officer, or a private detective, and you're looking for this kind of thing. So presumably, if somebody says, well, we're going to sue the company for putting out this output, it'll be very difficult to show, even apart from the First Amendment, that they're being negligent in just providing information. But if they know a lot about you, then it becomes much more plausible to say, well, that the user had asked these various queries, like, how do I deal with a spouse I can't stand? Do you have any advice on that? Well, that didn't work. Anything else? No, that didn't work either. How about undetectable poisons, right? Then you could come up with an argument. You know, your software is so fancy and so technical, so technically sophisticated. Somebody can even has actually shown that they can predict at some degree of probability based on your past queries and this one, whether in fact you're looking for criminal purposes. You should have done that. One possible answer is great. We want there to be such rules that pressure AI companies into sorting people this way, because we want them to provide output to the novelists, but not to the would-be murderers. Another possibility might be to say, well, wait a minute, we don't want to create legal obligations on these platforms or legal pressure that requires them to build a psychological profile of us and then decide whether we seem like trustworthy people or dangerous people. That's something that I don't think is being much talked about, but that is actually an important question at the intersection of privacy, free speech, tort liability, and probably regulation.
Well, and the third consideration, of course, is there's some DA somewhere in the country who's about to subpoena.
Oh yeah. That's
that
also
history
an important
too, right?
privacy question about the records, just whether they can be turned over in criminal or in civil cases.
So for those who don't know, the Seymour case out of Colorado, the DA just went to Google and said, who's been searching for this particular thing? And Google gave it up eventually. Out of all their users in all the world, who was searching for this particular string.
Which, like, theoretically, the Stored Communications Act should have had something to say there, but...
Yeah, but warrants surpass everything, right? As long as you get a warrant, you know, the company has to comply.
Yeah.
So. Okay, so it's Q&A time. I have lots of questions that I will ask if you don't. The way we're going to do this is you stand up at the microphone, but we are going to invoke the Weiser rule. And I see a lot of students in the room. One of you's got a brilliant question. Are you a student? Yes. All right, awesome. Come on up. You've saved your fellow students. And then everyone else should line up behind, and we have a healthy 25 minutes, so hopefully we'll get through a lot of these.
Yeah, my name is Menashe Shapiro. I'm a 1L here at Georgetown Law.
Awesome.
Even better.
I'm
Extra bonus
also
points.
with the minority staff of the Finance Committee for the U.S. Senate.
Man, okay.
So I have two advantages.
Yeah.
We went small already in talking about, well, if we don't regulate at the federal level, so then California might make standards for the whole world, at least for the United States. I guess I want to go big, especially thinking about that a lot of the AI regulation right now, at least the discussion about what AI regulation should look like, is taking place in sort of international consortiums. Is there a way, and is there a need, to sort of preempt the actions of other states
especially in light of that even our allies have vastly different approaches to free speech, to libel, to all of the issues that we talked about.
So yes, there's a big international component, and let's divide the world into friends and not friends. So when it comes to the sort of competitor nations, and here the big obvious one is China, right? I think it's totally reasonable to say AI is the technology of the future. We are totally uninterested in having our both knowledge and hardware used for these, to sort of help adversary nations with this, and so we're going to export control the heck out of all of this, right? I mean, you know, this is a big thing that companies like NVIDIA, for example, have to deal with, but I think that's absolutely appropriate. You know, with respect to the other countries, I mean, Europe is interesting here. You know, often it's very easy to kind of poo-poo European tech regulators because you can just say, well, Europe doesn't really have its own tech sector of any interest, and so sure, they can regulate because, like, what do they care? It's actually not true for AI. I mean, Mistral is very impressive, and so I think the Europeans have real skin in the game here. But at the same time, I actually am not that convinced that the Brussels effect is actually going to be as pronounced for AI as it has been for platforms. Certainly early indications don't suggest that it will be. OpenAI is just happy to not allow a lot of its most advanced capabilities in Europe. So, you know, I can talk to the fancy voice model right now, but if you're in Europe, you cannot. I think OpenAI is just betting that they can win this particular game of chicken, and they may well be able to. In part because you don't quite have the same, I don't know, network effect is the exact right term here, but you know, the reason that we all ended up after European, you know, I forget which European law it was, you know, you go to any website and you have to click 17, yes, I'll accept your stupid cookies, right? Unclear what this accomplished, is because there are good reasons for companies to just have one standard, right? I do wonder if for AI, it's actually maybe easier for just to have much more localized AI systems, and fine, the Europeans can have a worse version and the Americans can have the better version, and so that's what's going on there.
So if I could offer a related but slightly different answer, perhaps, I think a lot depends on how aggressive various foreign countries are going to be about this. And, you know, I disagree with the Thai view, as I understand it, that people should go to prison for many years for insulting their king, right? I think it's bad. I would be very good, very nice if they abandoned it. But if the Thai government says, look, you guys are whizzes at geolocation. You can geolocate to 99% reliability. We don't insist perfect reliability, but if somebody is using this software from Thailand, then you better make sure that it doesn't say anything to insult the king, again, to a high level of reliability. You know, I think AI companies might deal with that. Likewise, if the Turks say, if you can't say things that support whatever Erdogan's enemies are. Or if things are normalized eventually with Russia, but Russia remains much more restrictive than America if the Russians do the same, or if the Europeans do the same in various ways. But they could be more aggressive, right? They could say, look, it upsets us that the king is being insulted even in America by Americans to Americans, or it upsets us that supposed hate speech is being conveyed by Americans to Americans, so we are going to basically threaten to jail your any employees you have in our country and seize any assets you have in our country. Well, then in that case, they would be exporting their rules to us and constraining what Americans can see. I think if that happens, I think it's very important and probably a proper role for the government to try to stimulate, although I certainly wouldn't want it to try to code it, to have a all US-based AI company that says we pledge to have assets only in America, employees only in America, and as a consequence, we can assure you that we're in no way beholden to any foreign country that tells us what we may or may not produce.
Realistically, though, is that possible given AI supply chain and the vast majority of like people building training data sets are overseas?
So I think it's an interesting question. I think a lot has to do with the open source question.
Yeah, I was going to say the same thing, right? Like Meta has commoditized pre-training of the foundation models in a sense. Like Meta's grand gambit seems to have worked. And so, you know, 401 that just came out is not a pre-trained model. It's a bunch of really fancy fine-tuning. And so in a funny way, if you're Thailand, just use the latest llama. You get a bunch of your smartest computer scientists to fine-tune the heck out of it, and it probably will stop. Right, and so you said they'll have worse AI. I'm not sure they are. They're gonna have pretty good
but
AI.
Thailand may say, we have the Thai AI.
Yeah.
In fact, AI is part of our name, right? But it's not good enough for us because lots of our citizens are using that. But the other interesting point, of course, is it doesn't have to be 100%. I mean, imagine that there is this movement, and the Philippines says, look, we are thinking about having people doing various kind of low-cost training things. We have, I think it's about 100 million people in the Philippines now. A good deal of them speak English, let's say. And this is what we're going to offer. We promise not to leverage any of our control in this situation. So let us into your little walled garden, your big walled garden, the American walled garden. We'll provide these services. We'll promise not to interfere with that. So I think there would be mechanisms for dealing with that, I think.
All right, let's try and get through a few more of these. No, that was great. I love that.
Hi, thank you so much. I'm Shira from Meta. But I actually have a question about, really related, I think, to this question about the kind of international component of all of this. So Alibaba has recently released an open source model and has produced, there have been chatbots produced from it. I've been playing around with them. And from what I can tell, just from dog fooding, it seems as though there are certain, I assume, output controls, although I don't know technically how they accomplish this, where they just won't provide certain outputs about politically sensitive issues for China. So specifically, you ask it about Tiananmen Square, and it responds, I can't respond to that issue. What do we do? Like, how do I think about this?
Right. So this does raise actually a version of the Lamont v. Postmaster General problem, right? Which is also now pending in this fair city. In the TikTok case, right?
Right, exactly.
Do we have, whatever the normal First Amendment rules are, is there some extra power that the government has to try to restrict things that are substantially affecting American public discourse? Maybe that's one way of distinguishing Lamont v. Postmaster General. Like, foreign propaganda being mailed into the U.S. in 1965, probably not that big a deal, just because very few people read it. But if it's something that's TikTok, an important platform like that, or an LLM, let's say, that lots of people are using, and they get not just that, of course, this is like the 13th chime of the clock. Not only is it wrong itself, but it casts doubt on all that preceded it, right? If it just says no about Tiananmen Square, what other more subtle things there might be? Should there be a different First Amendment rule for that, saying, look, even if it does interfere in some measure with American listeners and American speakers' ability to communicate this way, given all the other options they might have that don't have these kinds of possibilities of foreign influence, would we be able to restrict that? I don't know what the right answer is, but again, I think that the TikTok case from the DC Circuit, and especially if it goes up to the Supreme Court, may very well have spillover effects on the very question you're describing.
And to be clear, I think you're absolutely right. To be clear, it's not that there's a TikTok case and it will tell us something about this AI question. The TikTok case is an AI question. It is an AI case because the one of the two justifications, and what I think everyone recognizes is the real justification in a sense, which is the TikTok algorithm's potential for interfering in the ecosystem. The algorithm is AI, and this gets back to Chinny's point, right? AI means many things, and generative AI is only one of those things. The algorithm is a very complicated machine learning something, right? And so, yeah, I think that's the question.
Can I just comment on both questions? What I find fascinating is, you started out by saying there aren't the same network effects, and then you took it back. And then Eugene was basically describing a balkanized set of large language models. And for 25 years, you were never allowed to say anything supportive about the balkanized internet. There was this kind of libertarian strand in the foundation of our debate where if you ever pictured a world where anyone's internet was not as capable as our internet, you'd just broke the first. I think we're much more comfortable with balkanized
digital
AI
sovereignty is-
and where it's trade war all the way down and where it's geopolitics at the highest level. You're not, based on the look on your face. And by the way, I'm one of the few published authors who have written like a love letter to the balkanized internet. So I'm just happy that the rest of the world is catching up to me. But it's fascinating to me. It's
I've been a heretic for a long time.
Yeah. Oh, really? I didn't know this about you. We should have formed a club. We're the two people.
Exactly.
So in a funny way, it's funny to me that like that libertarian argument, even if it makes you squirm a little bit, isn't table stakes. It used to be you can't say a bad thing about the global internet that we have. Yeah. Go ahead if you want to. You look like you're desperate to.
Well, if I may offer, I think one of the fundamental challenges with the balkanization of the internet is understanding how certain services work.
Yeah.
So there are, obviously, if you're thinking about data storage, then that might work in a balkanized environment. It's less effective and, in fact, maybe more destructive in an environment where the service itself is communication.
Yeah.
So, if you're going to balkanize internet from one of Meta's services, for example, like WhatsApp, the result may be that you just simply cannot communicate with someone in a different jurisdiction. So it'll be interesting to see how this plays out for AI. Certainly, we were thinking about this a lot in terms of bias. Where is the data that we're training on coming from, and what's the value of training on data from more diverse sources? But I think there'll be other ways it plays out too.
Let you have the last word on that.
So,
Great. Awesome.
Thanks.
Thank you.
Hi, my name's Sunny. I'm part of an org called Encode Justice. We're one of the 3 co-sponsors of SB 1047, so this is going to be a slightly pointed question. And so I think whenever I hear about people talking about federal preemption of state law when it comes to AI safety, I feel like this always just like mystifies me a lot because I think it goes like there's 2 big things. One is like it goes really counter to the whole laboratories of democracy, federalist kind of mindset that we've practiced in the U.S. for many other things. But also, there's like very real political realities of like Congress is barely even able to pass a continuing resolution, much less like actually legislate on major issues. And so I always, is the beef with California specifically, is it like you just, if this happened in Mississippi, would it be okay? Or like, I'm genuinely asking.
I'm going to break the fourth wall and show you all, if you haven't moderated a lot of panels, this is a moderator's trick. If you don't know the answer to something, you blame it on the students. So, scene. There are students in the audience, and we've now talked about the California bill twice. Do one of you mind summarizing like the key points of the bill, just so we know what we're talking about?
Oh no, it's a moving target. I have honestly lost track.
But can you? It sounds like you might be able to. Yeah, just a couple.
You're the co-sponsor.
Just a couple of high-level points.
Sure. Well, it's the bill has like 3 major things. The first thing that it does, which is the most controversial, I think, and the thing that gets talked about a lot, is that it puts on liability standards for frontier model developers above a certain amount of money and a certain amount of compute. These regulations would target like the largest model developers and kind of put on a reasonable care standard for catastrophic risks, which are like your chemical, biological, radiological, nuclear weapons, or critical infrastructure damage. And the other 2 things that it does is it puts on it gives whistleblower protections to people from the lab so that they can report to the California Attorney General if they find anything that they think is kind of controversial. And the last thing it does is establishes a public computing framework for California. Is that a fair characterization?
That was a beautiful summary.
Right. Yeah. I feel like I've given this speech a million times now.
Can I just mention, just to set the stage? The fact is that we believe in laboratories of democracy. We have lots of things that are governed by state law. And we believe in uniformity. We have lots of things that are governed by uniform federal law. So I think it's a mistake to assume that everything needs to be, because we have federalism, everything needs to be available for state action. It's a mistake to assume that because we have the Congress, everything needs to, or because in theory everything is more efficient if there's one rule, everything needs to be preempted. So for example, it's generally believed, I think, by people who know something about copyright, that it's a good thing there's one federal copyright law throughout the country. And that if a state says, no, we want to experiment some more with development of different approaches to copyright, different length of the term, different scope of coverage and such, generally speaking, we're kind of skeptical of that. Likewise, my understanding is that with a few exceptions, things having to do with broadcasting are federal and generally, you don't leave it to the states, among other things, because there could be broadcasters that operate in a tri-state area, right? On the other hand, there are lots of things which you might think, well, why don't we do it in a uniform way, that we don't do uniform way. So for example, just even in the area of speech and communicative torts, there are different libel law rules, and the same New York Times is in principle subject to the libel law rules of the 50 states, depending on where the people they're covering live and whether their articles are sufficiently focused on those people's behavior in those states. So I just want to flag, on the one hand, I totally understand the value of that, of having different state approaches, but at the same time, we shouldn't be mystified by the idea that why not federalize? Because in some areas, we do think that federal preemption is the right thing.
Yeah, and beautifully put, and I think this answers the question, totally reasonable, is would I be so exercised if this was Mississippi? And the answer is no, because it wouldn't matter, right? No, I'm not trying to rag on Mississippi. It just is a empirical fact that right now Mississippi, as far as I know, does not have any leading AI labs in it, right? If that were to change, then I would say the same thing about Mississippi. You know, the end of the day, you know, laboratories and democracies are great until those laboratories create externalities whose negative effects are greater than the benefits, right? Now, you may say, well, I don't think the negative effects are greater than the benefits because I think AI safety is so important, right? But my point is this should be decided at the congressional level. Now, the other question you put is, or the other argument, which is totally reasonable, is, and I think this is kind of something what Katrina was pointing out as well, is don't we have gridlock? Doesn't it make it impossible? Don't we need states to do this? Sure, but I actually think the gridlock is perhaps somewhat overstated because we do know that Congress
That's definitely controversial.
Well, I mean,
Alan is full of hot takes.
Well, but think of it this way, right? You know, think of how quickly the TikTok bill was passed, right? I mean, when Congress decides it really wants to do something, it is in fact capable of acting.
That was in response to a lot of state action, in part.
I think it was a response to the Republicans and the Democrats agreeing.
Yeah,
That's the thing,
I think
that
they
you
just
need
agree.
to have buy-in from both sides of the aisle in Congress today.
Yeah.
And maybe you can't, maybe you don't want to, but if you can, then things could happen. Maybe they would happen with regard to threats.
But if California passes the bill,
Yeah.
then isn't it, if we do think it needs to be preempted at a federal level, wouldn't we get some sort of bipartisan
I think your
agreement?
point that Congress could be especially forced by states, that's also true. You're quite right about that. I'm just saying there are things that Congress, or echoing what Alan was saying, there are things Congress will do. It's just you can't do it from just one side of the aisle.
And I think that when you look at, you know, I think when a lot of AI safety folks express frustration with Congress not acting, I think that frustration is totally reasonable. But I think the answer is Congress isn't not acting on this issue because, you know, everyone agrees but they can't get it together. It's because I think the main leaders in Congress simply just on a substantive level don't agree with the agenda, however righteous it may be, of the AI safety community, right? So when Senate Majority Leader Schumer released the AI Senate roadmap thing, it didn't include any discussion really of AI safety. Now, you can say that's a terrible thing, that's a bad document, right? And that's fine, but he didn't not do that because he couldn't talk about AI safety. He just doesn't agree with AI safety. So that's the issue, right? I just don't think there's a lot of appetite for this sort of AI safety legislation that, you know, would do meaningful amount to restrict the risks, and in the process, because there's a real trade-off here, might potentially harm innovation.
I do want to say, like, obviously, lobbying is a very powerful tool. It's the presence of like billions of dollars of lobbying in DC is impactful. It's more likely to happen at the federal level than maybe at the state level, or more effective at the federal level than at the state level, because Schumer did start out his whole roadmap, I'm going to have a bunch of fora on this with, I want to make safe and trustworthy AI.
That's true, but that assumes that lobbying isn't democracy. That's another
Oh
hot
my
take.
God.
So many controversial takes.
So Alan's
I'll
two
end there,
takes
yeah.
are Congress is super effective and yay lobbying.
Yep, that's right.
This is it.
That's right.
All right, this might be our last question. Go ahead.
Great. Yeah, thanks for the great panel. I'm Kendria Beers. I work on AI governance and safety at Georgetown Center for Security and Emerging Technology. I'm going to ask sort of the obvious AI agents and free speech question. So you've talked about how it's plausible that the output of generative AI systems can count as speech. How does this change in the case of AI agents, where that output might take the form of code or other instructions that are translated directly into actions in the real world? As a motivating case for this, it seems to me to be like quite plausible that an AI agent might decide that to accomplish its goal, it might be a good idea to like hack into a system, say, like produce code that will end up hacking into a system.
Yeah, so I've always taken a very skeptical view of the broad versions of code as speech. I agree that certain kinds of source code might be speech when they're basically communicated to other people in order that they may read them. And there are interesting questions having to do with things like the 3D printed guns debate, because it turns out that some of the 3D the 3D printer instructions are actually comprehensible to humans. Like, they look like blueprints. So blueprints may well be speech. But my view was always, when something is not communicated to a human, it doesn't have to be by a human, but if it's not communicated to a human, or at the very least, let's say there's no human in the mix, that's action, that's not speech. So if I write a program that creates code and then executes code, and that then communicates the code to somebody else's computer where it's automatically executed as well, all of those things, it seems to me, it's a good question whether it should be regulated, but I don't think the First Amendment has anything really to say about them. Now, I'm not completely certain about that as a descriptive matter, in part because the 3D printed guns question has led to a good deal of disagreement among lower court judges, and of course hasn't reached the Supreme Court. But at least what you're describing at that level, it seems to me that's not something, and I say this as someone with a fairly broad view of the First Amendment, but that, it seems to me, is something outside of the First Amendment scope.
Yeah.
Wait, quick follow-up. I'm intrigued then, I love that I have you on the record here, not under oath though, but
I think I blogged about it.
Yeah, no, but a lot of people make, who believe in the code is speech argument also make a lot of the one line in Sorrell, where Justice Kennedy, on the way to invalidating a Vermont law that was about keeping pharma away from doctors, says basically, and I don't remember the exact words, but data is speech. In this very freestanding way, but a lot, people have made a lot of that, yeah.
So I do think that data is speech is correct if it's shorthand for when people are communicating to each other.
Yeah.
That's protected. Even if it's not, we're communicating opinions, but we're communicating facts, or even communicating arrays of facts. So if I am sending you information that you're going to use because you read it and you make decisions based on it, it's communicative by me to you, me as a human, you as a human, then yes, in that respect, data is speech, which is exactly what was happening.
But it's not the noun data. I mean, I think people have read that more broadly.
It's the robot data.
But my point is, it's what you do with the data that
yes, data is speech is shorthand for communications from human to human, or human organization to human organization of information. Doesn't lose its speech protection simply because we label it data, simply because it's not opinionated, simply because it's a large array of facts.
Yeah, and I 100% agree with that, and this is why, whatever my skepticism of, let's say, SB 1047, I get very frustrated when people argue that SB 1047 would, whatever its policy merits, be an unconstitutional infringement on the First Amendment because model developers have a right to communicate, for example, open source parameters, right? Because again, I think that is not speech precisely because, not that data isn't speech, but because when you are sending a billion parameters or trillion parameters, you're not communicating between humans in the standard way.
It's not likely that somebody will sit and read them.
Negative 0.7 right there.
Yeah,
exactly.
Let's have a debate about this.
Yeah, exactly.
Okay, it's a sign, thank you very much for your question. It's a sign of how rich the conversation was that I didn't even get to ask about Chevron and local Bryan. I mean, these are all things we should talk about as we're milling around afterwards. Chinny is going to close us out with a farewell for the conference, but before we get to that, please join me in thanking this wonderful panel today.
It feels weird to go up to the podium after sitting here for closing remarks, but I do just want to reiterate the thank yous to everyone. Thank yous to Paul, the panelists, to Samantha, to the Georgetown Center for hosting us here. I'm really grateful to Omidyar Networks, without whom we would not have been able to put together this compendium of primers. I hope everyone reads the compendium of primers. I do want to say, like, my one request is, if you have read it and if you have thoughts on it, if you're like, you landed it and it does feel readable to a non-lawyer, like, that's helpful for us to know. If you're like, this absolutely is unreadable to a non-lawyer, that's also helpful for us to know. If you're like, it would have actually been more useful if you answered X question, we are hoping to continue this work to bridge the gap between us in our 80 to 100 page papers and the policymakers that are making decisions very fast, even if we don't want to weigh the pros against the cons right now. So, like, tell us what would be helpful and what's working and what's not working. That'd be really great.
Awesome.
That's it.
Thank
You're
you.
great.